Excellencies, distinguished guests, participants, ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh. Peace upon us. Good morning and welcome back to the 5th International Short Course for Legal Officers with the theme of Peace, Election and Democracy. Ladies and gentlemen, we have completed 2 fascinating paper presentations and discussions yesterday. And today, we still have many compelling discussions with proficient speakers in sparking today's forum. My name is Aacc Yumas. It's pleased to be here again as your master of ceremony. Ladies and gentlemen, we now enter the session 3 of the short course. This session theme is Election in Diverse Society, Challenges and Opportunities. And without any further ado, let us invite our moderator for this session from the Harsh Graduate School, Netherlands. Please welcome Dr. Jos de Langen.
Good morning, Your Excellency, ladies and gentlemen. For those who don't know me, my name is Joost de Langen. I'm indeed a member of the Hague University of Applied Sciences in the Netherlands. We've been working with the Mahkamah Konstitusi for over 5 years now, and we've had the great pleasure to have as guests almost 40 of their employees. It's my great pleasure to moderate today's fascinating discussion on the topic of elections in diverse society, challenges and opportunities. This is a very important topic, made all the more topical by the numerous crises that affect our daily lives and are threatening democratic discourse across national frontiers. It is my great pleasure to welcome our distinguished speaker for today. I say speaker, as Dr. Fagias unfortunately could not be here for today's session. We will open the session with His Excellency Judge Manahan P. Sitompul of the Constitutional Court of Indonesia. And following his presentation, we will have Ms. Ati from the Philippines and Ms. Yunita from Indonesia, who will act as discussants and kickstart the discussion, which will then be concluded by an open Q&A session. Usually now, I would say at 10:15 I will close the session, but I expect we will close a lot earlier due to the absence of Dr. Fagias. And I will invite you then to join me for a quick coffee break. I would like to invite His Excellency Judge Sitompul to come to the
the dynamics of constitutional court decisions in diverse society. The Constitutional Court, as the guardian of constitution and democracy, has made fundamental changes in the constitutional system, including in the context of realizing constitutional democracy. In its 19th year, the Constitutional Court has tried to organize Indonesia's democratic system toward a constitutional democratic state. Settlement of election disputes, regional head elections, and also review the constitutional laws are very influential authorities in changing the democratic system in Indonesia. The presence of the Constitutional Court not only enforces procedural justice, but also substantive justice, which reflected in its decisions. The constitutional rights of citizens guaranteed by the Constitution have been protected in every decisions taken by the Constitutional Court. The effort to protect and ensure human rights in Indonesia have been made continuously and have been increasingly showing progress. The fundamental effort to protect and enforce human rights have been made by making amendments to the 1945 Constitution in 1999 up to 2002. Currently, the formulation of human rights in Indonesia Constitution can be classified as very comprehensive, and it has made the 1945 Constitution to become one of world's most comprehensive constitution, setting out provisions on human rights protection. Why does amended 1945 Constitution comprehensively introduce the provision of human rights protection enforcement? In general, the inclusion of human rights in the article of Constitution is considered as a characteristic of a modern constitution as well as a prerequisite to the development of foundation of constitutions. Constitutionalism. Constitution as an instrument to reach constitutionalism must include provision on control over political power and protection of human rights. On such basis, Constitution should not only acknowledge human rights, but it also have to provide protection and guarantee for their fulfillment. Emphasis is given on this matter because the fundamental interest of every citizen is to have their rights and a human being and a citizen enforced and fulfilled. What is the difference between human rights and the constitutional rights of citizens? In my opinion, not all constitutional rights are human rights, although all human rights constitute the constitutional rights of citizens. In Indonesian context, constitutional rights are the rights provided for in the 1945 Constitution. It indicates that all citizens' rights provided for in 1945 Constitution fall into the category of constitutional rights, which must be guaranteed and protected without any exceptions. In that case, how does the Constitutional Court play its role in protecting the constitutional rights of citizens? Under Article 24C, paragraph 1 of the 1945 Constitution, the Indonesian Constitutional Court have 4 types of authority and 1 constitutional obligation. Namely, 1, to conduct a review of laws against the 1945 Constitution. Second, to settle disputes. To settle dispute authority between state bodies, which authority is granted by the 1945 Constitution. Third, to decide the solution of political party. And fourth, to settle disputes over the result of general election, and the Constitutional Court is required to make decision based on the opinion of the People's Legislative Assembly about the alleged violation by the President and or Vice President under the 1945 Constitution. Through such authority and obligation, the Indonesian Constitutional Court is principally established with the purpose of protecting the constitutional right of citizens from the norms of laws contradictory to the Constitution. The review of a law against the Constitution conducted by the Constitutional Court may be either formally or materially performed. In formal review, if the petitioner successfully proves the formation of a law is contradictory to the 1945 Constitution, which consequently impairs his or her constitutional rights, it means that the entire law shall be declared to be contradictory to the 1945 Constitution and shall not have binding legal force. At the same time, the material review is review related to paragraphs, article, and or certain section of a law which are deemed to be contradictory to the 1945 Constitution. If the petitioner successfully proves such matter, the aforementioned paragraph, article, and or certain section of the law shall be the paragraph, article, and or certain section which are declared by the Constitutional Court to be contradictory to the 1945 Constitution and shall not have binding legal force. The party which may submit a petition for review of a law against the Constitution is party which considers that its constitutional rights is impaired by the coming into effect of a law, namely A, an individual Indonesian citizen, including a group sharing the same interests. B, a customary law community unit insofar as they are still in existence and in accordance with the development of the community and the principle of the unitary state of the Republic Indonesia governed by law. C, a public or private legal entity, or D, a state body. In the case of judicial review, the object of such review is the abstract and generally binding norms of the law. Therefore, despite the impaired constitutional rights of the petitioner as the grounds for petition for review, such action, however, actually represents legal interest of the entire community, namely the uphold of the Constitution. In the case of judicial review, the People's Legislative Assembly and the President are not the defendants or respondents being responsible for the fault committed, but rather as the party concerned providing a description of the background and objectives of the provision of the law petitioned. It is intended that the provision subject to review is not constructed merely based on the view of the petitioner or the Constitutional Court, but also based on legislators' view, so that there is legal assurance on whether or not it is contradictory to the Constitution. With respect to decision, it is stipulated in the 1945 Constitution that the decision of the Constitutional Court shall be final, which means that there is no further legal remedies are available. The decision of the Constitutional Court shall also be binding as from its pronouncement in the decision. In the decision pronouncement hearing open for public, all parties, both state administrators and community, are required to comply with and be subject to the decision. In addition to the authority to conduct a review of law against the Constitution, the role of Constitutional Court in protecting the constitutional rights of citizens is also actually performed by virtue and authority to settle disputes over the result of general election, either presidential or vice president general election, legislative general election, or regional head general election. By virtue of aforementioned authority, the Constitutional Court safeguards the democracy by protecting the right of a citizen to elect and or to be elected in a general election, so as to be able to be granted in accordance with principle and rule of a democratic general election as assured under the 1945 Constitution. The Constitutional Court ensures that the right to elect and or the right to be elected as a citizen are shielded from manipulation and any form of misappropriation, which is not only contradictory to the democracy, but also detrimental to citizens. In the event that the result of general election is proven to have been obtained by manipulating the rights to elect and or the right to be elected and violating the principle of democracy, the Constitutional Court may rescind the aforementioned result of general election. Within the same framework for safeguarding the democracy, the Constitutional Court also plays a role in the effort to equalize democracy and nomocracy. Indeed, the emphasis between democracy and nomocracy is different, but it doesn't necessarily mean that it cannot be equalized. Democracy is focused on political aspect in order to uphold people's sovereignty, while nomocracy is focused on legal aspect. In the process, democracy tends to be rebellious and anarchic due to the leniency resulting from the freedom given to citizens. Moreover, the freedom is often expressed through behavior which is not only contradictory to the law and democracy, but also jeopardizes the integration of the unitary state of the Republic of Indonesia. In this context, by virtue of its authority, the Constitutional Court, as the body safeguarding the Constitution and democracy, equalizes the democracy and nomocracy. The Constitutional Court stands on the front guard to make Indonesia as a democratic constitutional state and democratic state under the laws, which also means taking a role in protecting the integrity of the unitary state of Republic of Indonesia. As the conclusion of the presentation, I reiterate that the Indonesian constitutional crowd plays a role in recovering the constitutional rights of citizens violated by the coming into effect of norms and law through the exercise of the authority to conduct a review of a law against the Constitution. Furthermore, by virtue of such authority to conduct a review of a law, the Constitutional Court is able to control the legislator so as to be prudent in the formation of a law. It shall not violate and or disregard the obligation to provide protection to the constitutional rights of citizens. In addition, by virtue of the authority to settle disputes over the result of general election, the Constitutional Court plays a role in assuring and ensuring that the right to elect and or the right to be elected as the constitutional rights of citizens are shielded from any form of manipulation and misappropriation detrimental to citizens. Likewise, the Constitutional Court plays a role in protecting integrity of the unitary state of Republic of Indonesia, namely protecting the democracy so as to be established in the accordance with under the 1945 Constitution. Hence, this is my presentation, and thank you. I give time to you.
Thank you. Thank you for your fascinating speech and for sharing your views on this important topic. To kickstart the discussion, I would like to ask Ms. Ati from the Philippines and Ms. Yunita from Indonesia to start the discussion. Perhaps Ms. Ati first.
Good morning, everyone. My name is Patricia Valanya. I'm an attorney in the Supreme Court of the Philippines. Thank you so much, Dr. Sitompul, for the very thorough discussion. We just have a few questions we'd like to ask, if that's okay. Some points that we found very interesting and would like further information on. So, Dr. Sitompul, you mentioned that the Constitutional Court is the front guard of making Indonesia a democratic constitutional state. You also mentioned that this court is empowered to decide election disputes. So we'd like to know, in the exercise of this role in deciding election disputes, does the court take a more, let's say, proactive approach, or is it more conservative or cautious? In particular, we'd like to know, what is the burden of proof or the type of evidence that is required to prove manipulation of elections? Does the Constitutional Court conduct hearings, or how does it receive this evidence? And what is the result if the Constitutional Court declares an election a nullity? Is another election held, or is there another process involved? So thank you very much.
Thank you. Is it working? No? Would you like us to repeat the question? Would you like us to repeat the question? Would it be possible to repeat the question? I'm sorry.
Of course, I'm sorry.
But
Okay.
perhaps someone can help. I think the interpretation machine doesn't work.
Okay.
It does? Perfect. Please.
Okay. Yes. Okay. Please play it again.
Hello.
Check.
Oh, there. Okay, so our first question, sir, is whether the Constitutional Court is more proactive in deciding election disputes, or if it's more cautious and conservative. And in relation to that question, we'd like to know what exactly the burden of proof is in election disputes, or the type of evidence that is required to be presented to the Constitutional Court. And in receiving this evidence, does the Constitutional Court conduct trial-type hearings, or how does it receive this evidence? And finally, sir, we just like to know, what is the result of a declaration of nullity of an election? Is another election held, or is there some other procedure or process? Thank you very much.
Thank you. Your Excellency.
Okay, I want answer in Indonesian. Please interpret to ada. Saya jawab ya dalam bahasa.
I'll answer in Bahasa Indonesia. So the question is whether the Constitutional Court takes a proactive approach and is prudent in receiving cases or regarding the general election. The question is regarding the evidence and if the case doesn't have sufficient evidence, whether it would be rejected or how will it proceed. That was the first question. The second question, if the case, will the election be repeated or is there rejected out of hand? So I will explain a little bit. For Indonesia, the general election cases are those that have that is a contradictory case. That means that it's adversarial. The person who won the election is then related to the case. The person who loses becomes the litigant in this case. So they are the claimant in this case. So this is then an arena for opposing proofs and evidence. So the party that the Electoral Commission has stated that they have lost the election, they have to collect as much evidence as possible to show that there were violations or other types of fraud conducted by the victor of the election. So therefore, this becomes the basis for proving that the claimant should. So the Electoral Commission would be involved in this case. So their duty is that if they are countered by the litigants, but as the party holding the election, they must maintain that they did their duty correctly. So in this case, the victor of the election has an interest, of course, to provide evidence to maintain their victory in the election that has been declared as the Electoral Commission as the executor of the election. So if the proof is not strong enough, of course, the case would be rejected. So the declaration from the Electoral Commission then holds. But if it is proven, the Electoral Commission's declaration can then be annulled by the ruling of the court. This is then the authority of the court to state that the litigant's claim is proven. The Constitutional Court states that the litigant should have won, and so it can be a joint ruling. This can be ruled simultaneously. But if there is some doubt, they can instruct to repeat the voting. So there are some cases where the court has ruled as such. Perhaps that is my answer to the first question. I'll return the floor to our moderator.
Thank you, Your Excellency. Please, can I then invite Ms. Unita to ask a question?
Okay, Jos. Thank you, moderator. Assalamualaikum warahmatullahi wabarakatuh. Our distinguished guests and participants, my name is Unita. I'm a substitute registrar in the Judicial Court of Indonesia. It's great for me to be here discussing His Excellency's Justice Manahan paper. That was very insightful presentation. Our topic in this session is election in diverse society, challenges and opportunities. His Excellency Justice Manahan explained about the role of Constitutional Court of Indonesia to settle dispute over the result of general election that ensures the right to elect and to be elected as a citizen. In a diverse society, pluralism is a precious treasure, but at the same time, it becomes a toxic that inherently dangerous to the future of the nation. In Indonesia, in every time of election come, either in presidential or governmental or parliamentary election, there's always quote-unquote drama causing by this pluralism. I remember in 2017, in the election of the governor of Jakarta, when Basuki Cahayapurnama as a Chinese non-Muslim candidate made his challenge in election. The dramatic campaign that thrown him in prison for 2 years for blasphemy charges, and he lost the election. It reminds me to one book I have read before. The title is Love Wins. It said, I quote, "Voting is the worst way to protecting minority rights." Well, I have to agree with this quote. Because election by voting is calculating by number of voters. So the election results are predictable. The winner must be from the majority group. Like, I never seen an Indonesian president from non-Japanese that vote by the election. Like there's no non-Chinese prime minister in Singapore or non-Malayu prime minister in Malaysia, right? Even in the oldest democratic country like USA, it was long awaited until we can see Afro-American president. So it's not easy to become minority in the democratic country. Actually, like the majority group, the minority group also have the right to vote and to be voted, like His Excellency Justice Manahan said in his paper. The minority group also have the right to take part in the government of their country and a right to participate in decision-making process. But the minority group have no equal opportunities like peoples in majority group. So this is my question, sir. I have a question for you. As a Constitutional Court Justice, I'd like to know from your point of view about the minority rights to access the right to participate in government and the right to be voted. As I am minority, I'm non-Japanese in Indonesia, of course I'm minority. I think you are also experience the same thing. You're non-Muslim and non-Japanese. I would like to know from your perspective about this minority rights in Indonesia. That's my question. Thank you, Jos.
Thank you for your very interesting question. I have to say, as a Dutchman myself, we are still waiting for our first female president. So I take notice, Your Excellency.
Baik, pertanyaan yang sangat bagus.
It's a very good question related to the diverse situation in Asia countries and also in other countries, the different religions, different ethnic groups. What about the rights of minority? How is it protected in the case of the right to vote or to be elected? I think this is governed in providing the right to vote as those with constitutional rights, as guaranteed by the 1945 Constitution. It is protected, and the right to be elected is also stipulated in the law. That's in the law on general elections. And also, this has been derived from the 1945 Constitution, whether they are minority or not. There are no issues that can be the foundation to differentiate them from the majority. So there are no issues that can differentiate them. However, in political practice, it's inevitable that we need to look at the reality because in the electoral contest, people are discrediting, quote unquote, their adversary in order that they gain more public attention or from their supporters. So constitutionally or by law, it does not appear that there is differences in the treatment those from the minority or the minority. So perhaps that's my answer to your question, Unita. Thank you.
Thank you, Your Excellency. Thank you for this very good question. We now have time for an open Q&A, so if I can invite anyone who has a question. And if not, I guess not. In that case, I would like to thank Your Excellency for your wise words. Like I said, usually now the second speaker would come, Dr. Vagias, but unfortunately he could not come today. He has some illness complaints. So therefore I'd like to conclude this session today, and I would like to ask you all to join us for a cup of coffee in the lobby. Thank you all.
Well, thank you so much for our moderator and speakers. For His Excellency Dr. Manahan M. Sitompul, thank you for the fruitful discussions. And our moderator today, Dr. Yos, thank you. Excellencies, participants, ladies and gentlemen, well, we have completed the third session of this short course. Before we proceed to the fourth sessions, let us take a break, around 15 minutes, and please back to this room at 10 a.m. Thank you.
Teman-teman, kalian tahu nggak selama ini apa aja sih yang udah dilakuin sama Mahkamah Konstitusi? Jadi, melalui putusannya, Mahkamah Konstitusi memiliki kewenangan untuk menguji undang-undang terhadap undang-undang dasar. Nah, Mahkamah Konstitusi juga menunjukkan kontribusi untuk menegakkan supremasi hukum, menguatkan demokrasi, sekaligus mengembangkan kesadaran dan kultur berkonstitusi warga negara. Juga nih, di antara putusan perkara pengujian undang-undang, banyak banget yang dinilai sebagai landmark decision. Landmark decision adalah putusan yang monumental dalam memberikan perlindungan hukum dan memulihkan hak konstitusi warga negara yang telah telah dijamin oleh Undang-Undang Dasar. Contohnya adalah hak keberatan anak di luar kawin dengan ayah biologisnya yang diputus pada tahun 2012. MK memulihkan hak anak di luar kawin dengan menyatakan inkonstitusional ketentuan dalam Undang-Undang Perkawinan yang menyatakan bahwa anak yang lahir di luar kawin hanya memiliki hubungan keperdataan dengan ibunya atau dengan keluarga ibunya. Tentu saja ketentuan itu tidak memberikan perlindungan hukum bagi anak di luar kawin dong. Oleh karena itu, MK menyatakan bahwa anak yang lahir di luar kawin bisa memiliki hubungan keperdataan dengan laki-laki yang dapat dibuktikan dengan ilmu pengetahuan dan teknologi melalui tes DNA dari ayah biologisnya.
Nah, selanjutnya ada putusan MK yang dinilai memulihkan hak masyarakat hukum adat terhadap hutan adat. Nah, pada tahun 2013 dalam putusan mengenai pengujian Undang-Undang Kehutanan dinyatakan bahwa menempatkan hutan adat sebagai bagian dari hutan negara merupakan suatu bentuk dari pengabaian terhadap hak-hak masyarakat hukum adat. Oleh karena itu, Mahkamah Konstitusi memutuskan bahwa hutan adat merupakan hutan yang berada dalam wilayah masyarakat hukum adat, jadi bukan lagi hutan negara yang berada dalam wilayah masyarakat hukum adat.
Selain itu, juga ada putusan berikutnya yaitu putusan yang berkenaan dengan hak asasi manusia atas air, di mana tepat pada tahun 2015, teman-teman, Undang-Undang Sumber Daya Air ini dinyatakan inkonstitusional secara keseluruhan oleh Mahkamah Konstitusi. Jadi, akses terhadap air ini merupakan bagian dari hak asasi manusia dan oleh karenanya, Konstitusi mengamanatkan hak penguasaan negara atas air. Putusan Mahkamah Konstitusi menegaskan bahwa Undang-Undang Sumber Daya Air ini tidak dapat menjamin terwujudnya hak penguasaan negara atas air karena itu dapat membuka peluang privatisasi dan komersialisasi pihak swasta atas pengelolaan sumber daya air. Privatisasi dan komersialisasi pihak swasta atas pengelolaan sumber daya air ini jelas merugikan hak konstitusional warga negara.
Nah, teman-teman, ternyata putusan MK ini monumental dalam melindungi dan memulihkan hak konstitusional bagi penghayat kepercayaan. Dalam Undang-Undang Administrasi Kependudukan dinyatakan bahwasanya kartu keluarga dan KTP elektronik memuat mengenai kolom agama. Namun, khusus bagi warga negara penghayat kepercayaan, ternyata kolom agama tersebut dikosongkan loh, teman-teman. MK menyatakan dikosongkannya kolom agama di kartu keluarga dan KTP elektronik bagi penghayat kepercayaan ternyata telah menimbulkan diskriminasi dan kerugian konstitusional bagi warga negara penghayat kepercayaan terhadap Tuhan Yang Maha Esa. Pada tahun 2017, MK memutuskan kolom agama dalam kartu keluarga dan KTP elektronik penghayat kepercayaan terhadap Tuhan Yang Maha Esa tidak lagi dikosongkan, melainkan dicantumkan penghayat kepercayaan tanpa merinci kepercayaan yang dianut. Nah, selanjutnya pada putusan Mahkamah Konstitusi yang satu ini juga merupakan tonggak penting Pancasila menjadi dasar pengujian undang-undang. Salah satunya putusan pengujian undang-undang tentang pencegahan penyalahgunaan dan atau penodaan agama pada tahun 2010. Putusan ini menggunakan tolak ukur sila pertama Pancasila, yaitu ketuhanan yang Maha Esa dalam memaknai prinsip negara hukum Indonesia. Mahkamah Konstitusi menyatakan prinsip negara hukum Indonesia tidak harus dimaknai sama dalam arti rehtat maupun the rule of law, melainkan harus dilihat dengan cara pandang yang menempatkan prinsip ketuhanan yang Maha Esa sebagai prinsip utama serta nilai-nilai agama yang melandasi gerak kehidupan bangsa sekaligus tidak semata-mata berpegang pada prinsip individualisme maupun prinsip komunalisme. Nah, dari putusan ini membuktikan bahwa selain Undang-Undang Dasar 1945, Pancasila sebagai dasar dan ideologi negara yang menjadi jiwa Undang-Undang Dasar 1945 juga dapat menjadi dasar dalam pengujian konstitusionalitas undang-undang. Nah, dari putusan-putusan itu membuktikan bahwa sebagai peradilan konstitusi, Mahkamah Konstitusi telah menjalankan peran dan fungsi untuk mengawal konstitusi, melindungi hak konstitusional warga negara, dan sekaligus menjaga ideologi negara yaitu Pancasila. Teman-teman, kalian tahu nggak selama ini apa aja sih yang udah dilakuin sama Mahkamah Konstitusi? Jadi, melalui putusannya, Mahkamah Konstitusi memiliki kewenangan untuk menguji undang-undang terhadap undang-undang dasar. Nah, Mahkamah Konstitusi juga menunjukkan kontribusi untuk menegakkan supremasi hukum, menguatkan demokrasi, sekaligus mengembangkan kesadaran dan kultur berkonstitusi warga negara. Terus juga nih, di antara putusan perkara pengujian undang-undang, banyak banget yang dinilai sebagai landmark decision. Landmark decision adalah putusan yang monumental dalam memberikan perlindungan hukum dan memulihkan hak konstitusi warga negara yang telah dijamin oleh Undang-Undang Dasar. Contohnya adalah hak keberatan anak di luar kawin dengan ayah biologisnya yang diputus pada tahun 2012. MK memulihkan hak anak di luar kawin dengan menyatakan inkonstitusional ketentuan dalam Undang-Undang Perkawinan yang menyatakan bahwa anak yang lahir di luar kawin hanya memiliki hubungan keperdataan dengan ibunya atau dengan keluarga ibunya. Tentu saja ketentuan itu tidak memberikan perlindungan hukum bagi anak di luar kawin dong. Oleh karena itu, MK menyatakan bahwa anak yang lahir di luar kawin bisa memiliki hubungan keperdataan dengan laki-laki yang dapat dibuktikan dengan ilmu pengetahuan dan teknologi melalui tes DNA dari ayah biologisnya.
Nah, selanjutnya ada putusan MK yang dinilai memulihkan hak masyarakat hukum adat terhadap hutan adat. Nah, pada tahun 2013, dalam putusan mengenai pengujian Undang-Undang Kehutanan dinyatakan bahwa menempatkan hutan adat sebagai bagian dari hutan negara merupakan suatu bentuk dari pengabaian terhadap hak-hak masyarakat hukum adat. Oleh karena itu, Mahkamah Konstitusi memutuskan bahwa hutan adat merupakan hutan yang berada dalam wilayah masyarakat hukum adat, jadi bukan lagi hutan negara yang berada dalam wilayah masyarakat hukum adat.
Selain itu, juga ada putusan berikutnya yaitu putusan yang berkenaan dengan hak asasi manusia atas air, di mana tepat pada tahun 2015, teman-teman, Undang-Undang Sumber Daya Air ini dinyatakan inkonstitusional secara keseluruhan oleh Mahkamah Konstitusi. Jadi, akses terhadap air ini merupakan bagian dari hak asasi manusia dan oleh karenanya, Konstitusi mengamanatkan hak penguasaan negara atas air. Putusan Mahkamah Konstitusi menegaskan bahwa Undang-Undang Sumber Daya Air ini tidak dapat menjamin terwujudnya hak penguasaan negara atas air karena itu dapat membuka peluang privatisasi dan komersialisasi pihak swasta atas pengelolaan sumber daya air. Privatisasi dan komersialisasi pihak swasta atas pengelolaan sumber daya air ini jelas merugikan hak konstitusional warga negara.
Nah, teman-teman, ternyata putusan MK ini monumental dalam melindungi dan memulihkan hak konstitusional bagi penghayat kepercayaan. Dalam Undang-Undang Administrasi Kependudukan dinyatakan bahwasanya kartu keluarga dan KTP elektronik memuat mengenai kolom agama. Namun, khusus bagi warga negara penghayat kepercayaan, ternyata kolom agama tersebut dikosongkan loh, teman-teman. MK menyatakan dikosongkannya kolom agama di kartu keluarga dan KTP elektronik bagi penghayat kepercayaan ternyata telah menimbulkan diskriminasi dan kerugian konstitusional bagi warga negara penghayat kepercayaan terhadap Tuhan Yang Maha Esa. Pada tahun 2017, MK memutuskan kolom agama dalam kartu keluarga dan KTP elektronik penghayat kepercayaan terhadap Tuhan Yang Maha Esa tidak lagi dikosongkan, melainkan dicantumkan penghayat kepercayaan tanpa merinci kepercayaan yang dianut. Nah, selanjutnya pada putusan Mahkamah Konstitusi yang satu ini juga merupakan tonggak penting Pancasila menjadi dasar pengujian undang-undang. Salah satunya putusan pengujian undang-undang tentang pencegahan penyalahgunaan dan atau penodaan agama pada tahun 2010. Putusan ini menggunakan tolak ukur sila pertama Pancasila, yaitu ketuhanan yang Maha Esa dalam memaknai prinsip negara hukum Indonesia. Mahkamah Konstitusi menyatakan prinsip negara hukum Indonesia tidak harus dimaknai sama dalam arti rehtat maupun the rule of law, melainkan harus dilihat dengan cara pandang yang menempatkan prinsip ketuhanan yang Maha Esa sebagai prinsip utama serta nilai-nilai agama yang melandasi gerak kehidupan bangsa sekaligus tidak semata-mata berpegang pada prinsip individualisme maupun prinsip komunalisme. Nah, dari putusan ini membuktikan bahwa selain Undang-Undang Dasar 1945, Pancasila sebagai dasar dan ideologi negara yang menjadi jiwa Undang-Undang Dasar 1945 juga dapat menjadi dasar dalam pengujian konstitusionalitas undang-undang. Nah, dari putusan-putusan itu membuktikan bahwa sebagai peradilan konstitusi, Mahkamah Konstitusi telah menjalankan peran dan fungsi untuk mengawal konstitusi, melindungi hak konstitusional warga negara, dan sekaligus menjaga ideologi negara yaitu Pancasila. teman-teman, kalian tahu nggak selama ini apa aja sih yang udah dilakuin sama Mahkamah Konstitusi? Jadi, melalui putusannya, Mahkamah Konstitusi memiliki kewenangan untuk menguji undang-undang terhadap undang-undang dasar. Nah, Mahkamah Konstitusi juga menunjukkan kontribusi untuk menegakkan supremasi hukum, menguatkan demokrasi, sekaligus mengembangkan kesadaran dan kultur berkonstitusi warga negara. Juga nih, di antara putusan perkara pengujian undang-undang, banyak banget yang dinilai sebagai landmark decision. Landmark decision adalah putusan yang monumental dalam memberikan perlindungan hukum dan memulihkan hak konstitusi warga negara yang telah dijamin oleh Undang-Undang Dasar. Contohnya adalah hak keberatan anak di luar kawin dengan ayah biologisnya yang diputus pada tahun 2012. MK memulihkan hak anak di luar kawin dengan menyatakan inkonstitusional ketentuan dalam Undang-Undang Perkawinan yang menyatakan bahwa anak yang lahir di luar kawin hanya memiliki hubungan keperdataan dengan ibunya atau dengan keluarga ibunya. Tentu saja ketentuan itu tidak memberikan perlindungan hukum bagi anak di luar kawin dong. Oleh karena itu, MK menyatakan bahwa anak yang lahir di luar kawin bisa memiliki hubungan keperdataan dengan laki-laki yang dapat dibuktikan dengan ilmu pengetahuan dan teknologi melalui tes DNA dari ayah biologisnya.
Nah, selanjutnya ada putusan MK yang dinilai memulihkan hak masyarakat hukum adat terhadap hutan adat. Nah, pada tahun 2013 dalam putusan mengenai pengujian undang-undang kehutanan dinyatakan bahwa menempatkan hutan adat sebagai bagian dari hutan negara merupakan suatu bentuk dari pengabaian terhadap hak-hak masyarakat hukum adat. Oleh karena itu, Mahkamah Konstitusi memutuskan bahwa hutan adat merupakan hutan yang berada dalam wilayah masyarakat hukum adat, jadi bukan lagi hutan negara yang berada dalam wilayah masyarakat hukum adat.
Selain itu, juga ada putusan berikutnya yaitu putusan yang berkenaan dengan hak asasi manusia atas air, di mana tepat pada tahun 2015, teman-teman, Undang-Undang Sumber Daya Air ini dinyatakan inkonstitusional secara keseluruhan oleh Mahkamah Konstitusi. Jadi, akses terhadap air ini merupakan bagian dari hak asasi manusia dan oleh karenanya, Konstitusi mengamanatkan hak penguasaan negara atas air. Putusan Mahkamah Konstitusi menegaskan bahwa Undang-Undang Sumber Daya Air ini tidak dapat menjamin terwujudnya hak penguasaan negara atas air, karena itu dapat membuka peluang privatisasi dan komersialisasi pihak swasta atas pengelolaan sumber daya air. Privatisasi dan komersialisasi pihak swasta atas pengelolaan sumber daya air ini jelas merugikan hak konstitusional warga negara.
Nah, teman-teman, ternyata putusan MK ini monumental dalam melindungi dan memulihkan hak konstitusional bagi penghayat kepercayaan. Dalam Undang-Undang Administrasi Kependudukan dinyatakan bahwasanya kartu keluarga dan KTP elektronik memuat mengenai kolom agama. Namun, khusus bagi warga negara penghayat kepercayaan, ternyata kolom agama tersebut dikosongkan loh, teman-teman. MK menyatakan dikosongkannya kolom agama di kartu keluarga dan KTP elektronik bagi penghayat kepercayaan ternyata telah menimbulkan diskriminasi dan kerugian konstitusional bagi warga negara penghayat kepercayaan terhadap Tuhan Yang Maha Esa. Pada tahun 2017, MK memutuskan kolom agama dalam kartu keluarga dan KTP elektronik penghayat kepercayaan terhadap Tuhan Yang Maha Esa tidak lagi dikosongkan, melainkan dicantumkan penghayat kepercayaan tanpa merinci kepercayaan yang dianut. Nah, selanjutnya pada putusan Mahkamah Konstitusi yang satu ini juga merupakan tonggak penting Pancasila menjadi dasar pengujian undang-undang. Salah satunya putusan pengujian undang-undang tentang pencegahan penyalahgunaan dan atau penodaan agama pada tahun 2010. Putusan ini menggunakan tolak ukur sila pertama Pancasila, yaitu ketuhanan yang Maha Esa dalam memaknai
Participants
prinsip negara hukum
who has not
Indonesia.
scanned the QR code
Mahkamah
yet,
Konstitusi menyatakan
so please
prinsip
kindly
negara
scan the
hukum
QR
Indonesia
code
tidak harus
at the front of the
dimaknai
ballroom
sama
before we
dalam arti
continue
lahiriah
the meeting for your
maupun
attendance.
rule of law, melainkan harus dilihat dengan cara pandang yang menempatkan prinsip ketuhanan yang Maha Esa sebagai prinsip utama serta nilai-nilai agama yang melandasi gerak kehidupan bangsa sekaligus tidak semata-mata berpegang pada prinsip individualisme maupun prinsip komunalisme. Nah, dari putusan ini membuktikan bahwa selain Undang-Undang Dasar 1945, Pancasila sebagai dasar dan ideologi negara yang menjadi jiwa Undang-Undang Dasar 1945 juga dapat menjadi dasar dalam pengujian konstitusionalitas undang-undang. Nah, dari putusan-putusan itu membuktikan bahwa sebagai peradilan konstitusi, Mahkamah Konstitusi telah menjalankan peran dan fungsi untuk mengawal konstitusi, melindungi hak konstitusional warga negara, dan sekaligus menjaga ideologi negara yaitu Pancasila. teman-teman, kalian tahu nggak selama ini apa aja sih yang udah dilakuin sama Mahkamah Konstitusi? Jadi, melalui putusannya, Mahkamah Konstitusi memiliki kewenangan untuk menguji undang-undang terhadap undang-undang dasar. Nah, Mahkamah Konstitusi juga menunjukkan kontribusi untuk menegakkan supremasi hukum, menguatkan demokrasi, sekaligus mengembangkan kesadaran dan kultur berkonstitusi warga negara. Juga nih, di antara putusan perkara pengujian undang-undang, banyak banget yang dinilai sebagai landmark decision. Landmark decision adalah putusan yang monumental dalam memberikan perlindungan hukum dan memulihkan hak konstitusi warga negara yang telah dijamin oleh Undang-Undang Dasar. Contohnya adalah hak keberatan anak di luar kawin dengan ayah biologisnya yang diputus pada tahun 2012. MK memulihkan hak anak di luar kawin dengan menyatakan inkonstitusional ketentuan dalam Undang-Undang Perkawinan yang menyatakan bahwa anak yang lahir di luar kawin hanya memiliki hubungan keperdataan dengan ibunya atau dengan keluarga ibunya. Tentu saja ketentuan itu tidak memberikan perlindungan hukum bagi anak di luar kawin dong. Oleh karena itu, MK menyatakan bahwa anak yang lahir di luar kawin bisa memiliki hubungan keperdataan dengan laki-laki yang dapat dibuktikan dengan ilmu pengetahuan dan teknologi melalui tes DNA dari ayah biologisnya.
Nah, selanjutnya ada putusan MK yang dinilai memulihkan hak masyarakat hukum adat terhadap hutan adat. Nah, pada tahun 2013, dalam putusan mengenai pengujian Undang-Undang Kehutanan dinyatakan bahwa menempatkan hutan adat sebagai bagian dari hutan negara merupakan suatu bentuk dari pengabaian terhadap hak-hak masyarakat hukum adat. Oleh karena itu, Mahkamah Konstitusi memutuskan bahwa hutan adat merupakan hutan yang berada dalam wilayah masyarakat hukum adat, jadi bukan lagi hutan negara yang berada dalam wilayah masyarakat hukum adat.
Selain itu, juga ada putusan berikutnya yaitu putusan yang berkenaan dengan hak asasi manusia atas air, di mana tepat pada tahun 2015, teman-teman, Undang-Undang Sumber Daya Air ini dinyatakan inkonstitusional secara keseluruhan oleh Mahkamah Konstitusi. Jadi, akses terhadap air ini merupakan bagian dari hak asasi manusia dan oleh karenanya, Konstitusi mengamanatkan hak penguasa negara atas air. Putusan Mahkamah Konstitusi menegaskan bahwa Undang-Undang Sumber Daya Air ini tidak dapat menjamin terwujudnya hak penguasaan negara atas air, karena itu dapat membuka peluang privatisasi dan komersialisasi pihak swasta atas pengelolaan sumber daya air. Privatisasi dan komersialisasi pihak swasta atas pengelolaan sumber daya air ini jelas merugikan hak konstitusional warga negara.
Nah, teman-teman, ternyata putusan MK ini monumental dalam melindungi dan memulihkan hak konstitusional bagi penghayat kepercayaan. Dalam Undang-Undang Administrasi Kependudukan dinyatakan bahwasanya kartu keluarga dan KTP elektronik memuat mengenai kolom agama. Namun, khusus bagi warga negara penghayat kepercayaan, ternyata kolom agama tersebut dikosongkan loh, teman-teman. MK menyatakan dikosongkannya kolom agama di kartu keluarga dan KTP elektronik bagi penghayat kepercayaan ternyata telah menimbulkan diskriminasi dan kerugian konstitusional bagi warga negara penghayat kepercayaan terhadap Tuhan Yang Maha Esa. Pada tahun 2017, MK memutuskan kolom agama dalam kartu keluarga dan KTP elektronik penghayat kepercayaan terhadap Tuhan Yang Maha Esa tidak lagi dikosongkan, melainkan dicantumkan penghayat kepercayaan tanpa merinci kepercayaan yang dianut. Nah, selanjutnya
Ladies and gentlemen, welcome back. We hope you enjoyed the coffee break. Now let us proceed to the fourth session of today's short course with the theme Maintaining Public Trust to Constitutional Court. I will introduce our moderator for our fourth session today. He is a legal analyst under the Legal and Court Administration Bureau of the Constitutional Court of the Republic of Indonesia and has been working at the court since 2018. Ladies and gentlemen, please welcome Mr. Paulus Rudi Calvin Sinaga. Well, Mr. Paulus, the floor is yours.
Thank you. So, good morning, ladies and gentlemen. As the moderator of this session, I would like to invite our speaker, Her Excellency Justice Eni Nurbaningsih, to join with me on the stage. Thank you very much. Ladies and gentlemen, distinguished participants of the AACC International Short Course, my name is Paulus Sinaga. It's an honor for me to moderate this session because we already have with us today one of the justices from the Constitutional Court of the Republic of Indonesia as the speaker of this fourth session of the AACC International Short Course. On this session, we will have the opportunity to learn from the Constitutional Court of the Republic of Indonesia on how to maintain and increase public trust to the judicial system. Regarding that matter, allow me to give some brief statement. So the Constitutional Court of the Republic of Indonesia was established in 2003. One of its functions is to conduct judicial review of laws against the 1945 Constitution, both materially and formally. The implementation of the principles and values of the Constitutional Court is an important factor for protecting the rule of law and the supremacy of Constitution. Those aspects can also affect directly to the public trust to the judicial system. Ladies and gentlemen, distinguished participants, I am honored to introduce you to our speaker, Her Excellency Justice Eni Nurbaningsih. She is the former head of the National Law Development Agency of the Ministry of Law and Human Rights. She is also professor of law from Gajah Mada University. One thing that is unique about her is that currently she is the only female constitutional justice in Indonesia, among other male constitutional justices. And in this session, she will present her paper to us titled Maintaining Public Trust to Constitutional Court. Ladies and gentlemen, allow me to introduce you also with our discussion for this session. The first discussion is Mr. Jae Na-wo from South Korea. And the second discussion is Mrs. Ana Agung Dian Onita. She is substitute registrar at Constitutional Court of the Republic of Indonesia. Ladies and gentlemen, before our speaker present her paper, please let me inform you how we will get through this session. The session will last for approximately 1 hour. The speaker will have a 20-minute presentation, and then we will have a 15 minutes discussion with the discussants. Lastly, we will move to the last part, which is question and answer with the other participants for around 15 minutes. And now I'm delighted to turn the floor over to Justice Eni Nurbaningsih. The time is yours.
Thank you, Mr. Chairman. Assalamualaikum warahmatullahi wabarakatuh. The name of God, my peace and prosperity be upon us all. Good afternoon, good morning, and blessing of all of us. Honorable delegates from AACC, distinguished participants, and ladies and gentlemen, I am honored to be part of this concert course, and I would like to express my sincere gratitude to be invited as speaker in this session. The topic is how we can maintain public trust to the Constitutional Court. If we are talking about how we can maintain public trust to the Constitutional Court, I think this is easy for saying, but I think it's not easy for applicating, maybe. For this session, I have one question: how to maintain public trust in the judicial of the Constitutional Court must perform its duties and by adhering to ethical standard, effectively carrying out internal oversight, and good judiciary governance. I want to share a highlight of historical of Constitutional Court in Indonesia. This is related with the topic. The establishment of the Constitutional Court in Indonesia is triggered by a variety of reasons. In general, it is initiated by the process of political change from authoritarian power to constitutional democracy. The constitutional reform in Indonesia started in 1998 with a regime change from authoritarian to a democratic state. And one of the developments resulting from the constitutional reforms is that Indonesia created a new constitutional court. In line with the momentum of the amendment constitution during the reform era, the Constitutional Court of Indonesia was established under the Third Amendment of the 1945 Constitution, 2001, and it was officially established on 30 August 2003, along with the enactment of the Law Number 24 regarding the Constitutional Court. With Law Number 24 as the starting point, and with reference to the principle of balance among the branches of state's powers, the requirement of Constitutional Court justices was conducted by three state institutions, namely Parliament, President, and Supreme Court. After undergoing the selection stages according to the applicable mechanism, in each of the aforementioned institutions, its institution nominated three candidates for Constitutional Court justice to the President to be stipulated as Constitutional Court justices. The Constitutional Court of Indonesia is one of the state institutions exercising independent judicial power in administering the judicial system with the aim of enforcing law and justice. The Constitutional Court has 5 authorities as mentioned in Article 24C, Paragraph 1 and Paragraph 2. The authority of the court include hearing cases at the first and final stage, the decision of which are final in conducting judicial review of the constitutionality of acts, in deciding dispute concerning the authorities of state institutions whose authorities are vested under the Constitution, in making decisions regarding the dissolution of political parties, and in deciding dispute arising from the result of general election. It also the court's responsibility to make decisions concerning opinion of the House of Representatives related the alleged violence committed by the President and or Vice President against the Constitution. Based on its power and authorities, the Constitutional Court essentially functions as a guardian of the Constitution, democracy, and constitutional rights. Whenever there are laws that are repressing and revoking the constitutional rights based on request by the people, the Constitutional Court of Republic of Indonesia can play its role to protect, to promote, and to rehabilitate the institutional right of decision from such suppressions. Based on these important authorities and functions, the Constitutional Court must establish and maintain public trust through its core responsibility of resolving constitutional disputes, guided by the principle of procedural fairness. The Constitutional Court must enhance public trust by treating every party, including applicants, state institutions, expert witnesses, and other parties with dignity and respect. Moreover, the court justices and their supporting staff must help promote and maintain public trust by creating organizational culture that foster integrity, transparency, and accountability in every court processes. Ladies and gentlemen, Public trust to the court is further enhanced through the transparency of court procedures, providing public information regarding the court processes and hearing schedules, easy access to the court and services, and accessing the public documents such as decision, regulation, e-journal, and research reports. Regarding judicial procedures, the Constitutional Court has established the procedural law related to the court hearing session. There are 3 types of hearings. Firstly, panel hearing, plenary session, and deliberating justice meeting. I want to give more information about the panel hearing. The panel hearing is a hearing which consists of 3 Constitutional Court justices assigned to carry out the task of conducting preliminary examination. This hearing is conducted to examine the petitioner's legal standing and the substance of petition. Constitutional Court justices may give advice for revision of the petitioner. And the second one, plenary session. A plenary session is a hearing conducted by the panel of Constitutional Court justices attended by at least 7 justices. The hearing is open to the public with the agenda of hearing, examination, or decision pronouncements. Hearing examination includes listening to the petitioner, the statement of witnesses, experts, and related parties, as well as examination of instruments of evidence. Both of process above is transparent. And then the last point, the deliberating justice meeting. The meeting is closed and confidential. The meeting can only be attended by justices and the registrar. At the meeting, verdict of the Constitutional Court are discussed in depth, in detail, and comprehensively. And then this meeting must be attended by at least 7 justices. During the meeting, the registrar takes notes and records every discussed item and the conclusions. Another issue to maintain public trust, I would like to share a court system. As a modern and reliable judiciary, the Constitutional Court of Indonesia applies a court system. A court is a form of technology-based judicial service that aims to improve the community access to justice and access to the court. A court system is applied to the concept of judicial administration system, which includes the following. First one, electronic petition management information simple. We call it simple. Simple, it means easy. The system is realized, among other things, in the form of simple. With the system, people can do online registration, obtain a decision of the court, the minutes of the hearing schedule, the monitor the progress of the case online. Simple can be accessed through the website of the Constitutional Court by selecting the menu item Simple. The second one, online information retrieval. The system is a system of retrieve case files, minutes, and decision of the Constitutional Court easily when needed. This system includes digital online system and archive system. And then the court recording system. The court recording system is a technology which is able to record the entire hearing process, store it in audio and video data formats. With the help of the technology, the hearing transcript, including minutes and decision, can be directly accessed by the public several hours after the hearing is held. The fourth one, case minute management system. The system is a technology developed for recording the process of petition and proceeding at the Constitutional Court. The system and technology are available on the website of the Constitutional Court and in the online case system. The last one, video conference. video conference functions to increase public access to the Constitutional Court. Parties whose statements are needed in the hearing of the Constitutional Court while they are in certain areas located quite for the hearing venue of the Constitutional Court need not be physically present before the Constitutional Court, as they can use a Zoom application or to go to any one of the 42 law faculties in every province, cooperation with the Constitutional Court, to conduct long-distance hearing utilizing video conference technology. This technology is also needed in cross-country cases or cases requiring the statement of the witnesses or expert from abroad. Furthermore, ladies and gentlemen, the internal organization of the court is supported by Secretariat and Registrar Office. The court would not be able to function properly without their support. The substance, methods, and the direction of the court's work are determined by 9 constitutional justices along with the support of the court Secretariat and Registrar Office. In line with the duty and the authorities assigned, the court decisions are extremely important, as such decision manifest the ultimate achievement of the justices and the barometer in defining the existence of each institution known as the guardian of the Constitution and the final interpreter of the Constitution. The significance of constitutional justices is in fact the state administrative judicial institution would be meaningless without the support of the court secretariat and registrar office. Therefore, to improve public trust, the capacity and professionalism of the personnel of the Secretariat General and the Registrar Office of the Constitutional Court are also being continuously enhanced. This is done through a series of activities related to employee development efforts, namely education and training, technical, structural education and training, title, pioneering and internship at the Constitutional Court or Supreme Court or of friendly countries. Ladies and gentlemen, another effort to maintain public trust is that the court justice is also guided by the Code of Ethics and Conduct of Constitutional Justice. Under the Constitutional Court law, it is regulated that for the purpose of maintaining and enforcing integrity and enforce impeccable personality, justice and statesmanship, justice shall be required to adhere to the Code of Ethics. The Constitutional Court has enacted Constitutional Court Regulation Number 9, 2006, concerning the enforcement of the Declaration of the Code of Ethics and Conduct of Constitutional Justices. The Code of Ethics basically adopts the Bangalore principles, which are intended to establish standards for ethical conduct of justices. They are designed to provide guidance to justice and to other the judiciary of framework for regulating judicial conduct. 7 core values are recognized: independence, impartiality, integrity, prosperity, equality, and final competence and diligence. The principle define their meaning and elaborate in detail on what kind of conduct is to be expected in concrete terms of the persons concerned in order to put the respective values into practice. To enforce the Code of Conduct, the Honorary Council of the Constitutional Court, the name is Majelis Kehormatan Mahkamah Konstitusi, or MKMK, is established, which has the function of monitoring, examining, and recommending the measures to be taken against Constitutional Court justices who are alleged of having violated the Code of Ethics for Justices. However, the MKMK is a temporary institution. It will only be established when a constitutional justice is found violating to the Code of Ethics. In addition, the court also established the Board of Ethics of Constitutional Justices as a permanent institution which cannot be separated from the effort to uphold a code of ethics and maintain of dignity of the constitutional justices. These efforts are to ensure the proper provision of services that can maintain public trust to the court. Therefore, the services to the petitioners and the stakeholders and the community must also be implemented in the best possible manner. Ladies and gentlemen, it is not possible to cover all aspects of the topic in a single presentation. Summarizing the above, I would like to note that maintaining public trust to the court is a fundamental important for the development of the constitution and constitutionalism. I think that this short course will help us all better understanding the issue raised for discussion, exchange positive experiences, and develop effective ways to solve modern challenges on how to maintain public trust to the court. Thank you very much for your attention.
Please give a round of applause to Her Excellency Justice Endana Gubanisi. Thank you very much for the presentation. So the next part is that the discussions will give their review. I would like to invite Mr. Jae-na Wo from South Korea to give some review or maybe some question regarding the topic presented earlier. So the floor is yours.
Assalamu alaikum. Your Excellency, first of all, I thank you for your insightful presentations. That was very comprehensive. I guess that the public trust is a key in building the stability of the rule of law and the development of the democracy. As Your Excellency mentioned, the Constitutional Court should function as a guardian of the Constitution, democracy, and constitutional rights, and the transparent court procedures can enhance the public trust to the court. I believe that the Korean court and Indonesian court has very similar elements in terms of the procedures, providing the court processes and hearing schedules. And also our e-court system also enables people to submit documents for constitutional complaints, track document delivery and case registry, etc. I would say that the Korean Constitutional Court is the most trusted national institution by the people of Korea. We understand how important it is to maintain political neutrality and realize constitutional values in order to gain the public trust. In the past few years, our court has dealt with some important cases, such as the impeachment and the dissolution of the political party. I won't go into details about the cases here, but these cases served as a momentum in order to judge the Biden ruling powers that took down the trust of the people of Korea and also secure the normative power of the Constitution. And this is my question to Your Excellency. I'm wondering which major cases of the Indonesian court have played an important role in enhancing the public trust of the people of Indonesia to the Indonesian court. Thank you.
Thank you very much. Now I would like to invite Mrs. Dian Onita to give her opinion or question regarding the topic presented earlier. So the floor is yours.
Good afternoon. Thank you for the Prof. Eni for the presentation, and thank you for Paul to introduce myself. And also I don't need to introduce myself again. Based on your paper as a modern and reliable judiciary, there are a lot of applications to improve the community access to justice and access to the court. We can see all of system in our website that that will be to become the transparent and court procedure. As an employee, to improve the public trust, we have to, or we can follow a lot of training, intensive, detailed planning, and others. And for the justice, we have a guide, the Code of Ethics and the Conduct of Constitutional Justice, the Code of Ethics. The Code of Ethics designed to provide guidance for our justice. There are 7 core values: independence, impartiality, integrity, property, equality, and finally competence and diligence. The problem is this enough when we have a good system and we was implemented the good government principle? Of course not, because we ever had a bad experience when our Chief Justice on 2013 have a bribery case by the Anti-Corruption Commission. That not just once, but twice. Well, when we still repair our public trust, suddenly our justice raised it again by the Anti-Corruption Commission in 2015. From that case, as a justice, I want to ask you, we know our decision is our crown, so we have to try hard to make a decision with a high quality. Sometimes we have to become a problem solver too. As a justice, I know, and as we know, you are a representative from the government, from the president, and you have a lot of relationship with your colleagues, with your friend, as a lawyer, as a government, as a politician, as a lecturer too. How to fortify yourself to be independent and impartiality. Because sometimes we know when your friend needs your help, and that's influence or have effect for your decision, that will be a big problem as a justice, so you can be not impartial again. And for us, maybe you can give us the advice for the legal officer here, as a reporter, as a substitute registrar. Maybe you can give us advice if sometimes, for example, we meet the justice who has not have impartial. So sometimes we, as a human, we have to feeling if there is something problem with our decision. Some things we have feeling if there is conflict with our decision. Maybe you can give us to what should we do if we meet the justice who has not have a independency and impartial and integrity. Because as a leader, it's so difficult for us to refuse the order. Thank you, Paul.
Thank you very much. I think it's time for Her Excellency to give her response. The floor is yours.
Thank you very much for your, I think this is a hard question for me. Therefore, I said for my first presentation that how to maintain public trust is easy for saying, but I think sometimes difficult for applicating. I think in Constitutional Court of Indonesia, we have law number 24, and then amendments third times, and then we have a lot of regulation come from Constitutional Court by own self, and then based on the Constitution, the requirements to be a justice, I think it's not easy, because the Constitution mentioned that the requirements to be a justice, we have should be to be a statement. I think this is a higher values if we talking about the statements. How we can make a good decision as a crown of courts. I think all of the process for making process of the decision. Now the process is very very strict process. Not everyone can enter the deliberating justice meeting. Only justices and registrar, what we call it, disumpah, yeah, registrar, determined registrar, can be followed the process for decision making process, and all the processes from the panel session and the plenary session is open and transparent and easy for access for everyone. Everyone can follow all of the process. And now everyone can, I think, follow which one is the process is wrong. Yeah, this is the strength of mechanism after the ONITA from Indonesia, the substitute registrar, mentioned about the problem. Yeah, I think very long ago, but twice justices ditangkap arrested by the corruption commission. This is a very long time ago, I think. But now we try and on to improve all of the process, that the process still in the right way. We cannot. I want to give the example for my own self. I come from university. I have a lot of friends. I have a lot of colleagues. I have a lot of my relation like that. But as when the president appointed me after all of the selection and appointed me to be one of justices come from the president, I closed all of the media, social media, and WhatsApp, everything that relation with the my colleagues and my relationship like that, and I only has the social media or WhatsApp only my own family. I try to apply what's of the meaning is a statement regarding mentioned in the Constitution. Yeah, I think this is a very hard very hard effort when we mentioned long time ago that you mentioned, Onita mentioned twice justices arrested by the KPK. I think we have to improve ourselves and then to change all of the opportunity that have a bit opportunity to relate with the justices. Yeah, I think this is my response. Thank you.
Thank you very much. But I think we will move to the next part, which is question and answer session. We have 25 minutes left, and I think we can open 3 questions maybe. So is there any participant who would like to ask some questions? Yes. Can you state your name and your institution and also your question? Thank you.
Good morning. I'm Celine Carpio from the Supreme Court of the Philippines. Your Excellency, thank you for your enlightening presentation. So my question is, in your presentation, you mentioned that video conference is part of your judicial administration system. So we would just like to know if you are implementing this video conference prior to the pandemic, or is this a response to the COVID-19 pandemic? And then second, is the video conference session applicable to litigants or witnesses who are residing abroad or temporarily outside Indonesia? If yes, how does the video conferencing work? Do they need to be in the embassy in that particular country for the Constitutional Court to acquire jurisdiction over them? So I am very curious about your procedure because in the Philippines, our procedure for video conferencing for those who are residing abroad, they need to be in the particular embassy or consulate in that particular country. Thank you.
Thank you very much for the question. Maybe Your Excellency can answer.
Thank you very much. Based on aforementioned my presentation, we have a video conference. The video conference conducted by the Constitutional Court of Republic of Indonesia because the court has one mission as how we can easy for access for everyone to the Constitutional Court, and then we have one vision as a digitalizing of all of the process. Yeah, regarding the video conference, we have collaboration with 42 universities. So everyone, if want to be petitioners, then not need to go to the Constitutional Court in a capital city. Because you know that in Indonesia is a wide country and island country, and then I think maybe we have to consider the petitioner maybe come from the poor people or quite far and not easy for them for going to capital city, and then we provided the video conference for them in the university close with near with their place or they're staying there. And the second one, video conference, used not only for the 42 university, but we can use the video conference not only in the pandemic era also, but we use it for day by day. Like the case of narcotic, the witnesses and the expert not come from Indonesia, but come from some countries, and they can use the video conference as an expert invited by the petitioners to give explanation, their expectation, their expert on the narcotica, and then we can listen all of their explanation, not only by the 9 justices, but for everyone. So I think video conference hopefully all of the everyone, if they want to get access to Constitutional Court of Indonesia. So I want to stressing that not only for the pandemic era we use it, but day by day we use it. Yeah, thank you.
Thank you very much, Your Excellency, for the response. Now I'll open the second session. The second question. Is there any participant who would like to ask question? Okay, you can ask your question, Mrs. Unita.
Thank you, Paul. Her Excellencies, my name is Unita. I'm a substitute registrar. I can hold myself not to ask this question. Actually, this is hot topic now, relating to my colleague question before that you answered, that you choose to close yourself from your colleague, your relation, to imply for impartiality and your integrity. But as a justice that appointed by the president, how come you release yourself from the bond, the bond between you and the president that point to you? So it's a quite hot topic now. How the justice release their bond to the institution that appoint the justice? That's my question. Thank you, Her Excellencies.
Thank you. Your Excellency, please.
Thank you, Unita, as a substitute registrar. I think enough point to be professional. To be professional, I think. We know that, like Korea, justices selected by the Parliament and Supreme Court and also President. But they can make distancing between the processing for selecting and then when we to be a justices. I think to be professional. I try to be a professional now as a justice. Yeah, even though you know that I am only one woman justice in Constitutional Court of Indonesia, but until now, yeah, I do hope forever I could be professional as a justice. Yeah, I know that I have the president appointed me or selected me to be a justice, but I can understand which my position as well. So this is the point, is to be professional. Thank you.
Thank you very much. Are there any more questions from the participants? Oh yes. Sir, can you state your name and institution and your question? Thank you.
Can you hear me? My name is Jeff Epperson, and I'm the Vice President for the National Center of State Courts in the United States. This conversation has been excellent, and it reminds me of my 30-year career in the federal judiciary. And during that career in managing our courts, where the judges are appointed by the president, it reminded me that as I watched the transition of our federal judges from lawyers to judges, I always had questions also about whether those relationships would interfere with their decision making. And Madam Justice, when I heard you speaking, it triggered my memory, and that memory was almost all the judges that were appointed by the president, and it was Obama, it was Reagan, it was Carter, there was a transition. And I noted in the justices' sincerity that that transition was one from relationships to duty. And I took an oath as well to defend our Constitution in the United States. And for me, like my colleagues in the federal court, that sense of duty became more important than the relationships. And I think that's important. But also, I had a question, Your Honor. I wanted to kind of bring that up because this conversation is critical to legitimacy and public trust. The other question is, when I managed courts, we had a process for trying to gauge the level of public trust, Your Honor, and we watched public surveys closely. Even though it was hard to change public opinion, we did try to understand how the public was reviewing our performance as a court system. Do you watch the press and do you watch public opinion surveys? How do they affect the management, in your opinion, of the court system? That was my question. Just a thought. Thank you, Your Honor.
Thank you very much for the question. I would like to invite Your Excellency to give a response. Thank you.
Thank you very much for your questions. I think in Constitutional Court of the Republic of Indonesia, we have Secretary General. In the Secretary General, they have some of the offices regulate with the public services there. So the public services is separated with the justices, official. All of the public services served by the Secretary General. This is not any relationship between public services and then justices. We close everything with the public services. We know that sometimes public services has interest, maybe sometimes, if the public services may be related with a case like that. So we can separate it by the institutional structure in Constitutional Court. This is Secretary General, this is the registered office, and then this is the justices, 9 justices. 9 justices should be clean and clear, because we learn more and more come from the cases for long time ago. So we try to improve time to time, on and on, how we can make a decision as a crown decision and can give justices for everyone, can close the access for public. This is our function. So I think as a professional, as a justice, I think we have to make the system like that. So everything, the system for everything is online now. Everyone can look at, close everything of the process in our constitutional courts. This is my answer. Thank you.
Thank you for the response. We still have around 5 minutes left. So are there any more questions from the participants? Well, I think there are no more questions, so thank you very much. Before we end this session, I would like to give a brief summary. The Constitutional Court of the Republic of Indonesia maintain its public trust, firstly by improving transparency and accountability on court services, secondly by implementing e-court system, and thirdly by establishing and enforcing Constitutional Court Code of Ethics. I think that's the summary. Thank you very much, and I'll return this event to the master of the ceremony.
Thank you so much for our speakers and of course our moderator as well, once again, for Her Excellency Professor Dr. Eni Nurbaningsih, SHM, for a compelling discussion, and Mr. Paulus Calvin Sinaga. So we take a picture first. Please stay on the stage to take a picture, to take a photo. With all participants. Okay, we invite all participants to come up the stage to take a picture with our moderator and speaker. Thank you, everyone. So that's the end of the fourth session. Next, we will have lunch break before we proceed to the next session. For your information, ladies and gentlemen, the next session will be served as a sharing session between participants of the short course, and also we have a special sharing session as well by Mr. Jeffrey Epperson from the National Center for State Courts of the United States. Lunch can be enjoyed at Singaraja Hall at the 3rd floor. And please to gather here at this ballroom again at 12:50 for the next session. And lastly, we would like to remind you to scan QR code as well for the attendance data. Thank you so much and enjoy your lunch.
teman-teman, kalian tahu nggak selama ini apa aja sih yang udah dilakuin sama Mahkamah Konstitusi? Jadi, melalui putusannya, Mahkamah Konstitusi memiliki kewenangan untuk menguji undang-undang terhadap undang-undang dasar. Nah, Mahkamah Konstitusi juga menunjukkan kontribusi untuk menegakkan supremasi hukum, menguatkan demokrasi, sekaligus mengembangkan kesadaran dan kultur berkonstitusi warga negara. Juga nih, di antara putusan perkara pengujian undang-undang, banyak banget yang dinilai sebagai landmark decision. Landmark decision adalah putusan yang monumental dalam memberikan perlindungan hukum dan memulihkan hak konstitusi warga negara yang telah dijamin oleh Undang-Undang Dasar. Contohnya adalah hak keberatan anak di luar kawin dengan ayah biologisnya yang diputus pada tahun 2012. MK memulihkan hak anak di luar kawin dengan menyatakan inkonstitusional ketentuan dalam Undang-Undang Perkawinan yang menyatakan bahwa anak yang lahir di luar kawin hanya memiliki hubungan keperdataan dengan ibunya atau dengan keluarga ibunya. Tentu saja ketentuan itu tidak memberikan perlindungan hukum bagi anak di luar kawin dong. Oleh karena itu, MK menyatakan bahwa anak yang lahir di luar kawin bisa memiliki hubungan keperdataan dengan laki-laki yang dapat dibuktikan dengan ilmu pengetahuan dan teknologi melalui tes DNA dari ayah biologisnya.
Nah, selanjutnya ada putusan MK yang dinilai memulihkan hak masyarakat hukum adat terhadap hutan adat. Nah, pada tahun 2013 dalam putusan mengenai pengujian undang-undang kehutanan dinyatakan bahwa menempatkan hutan adat sebagai bagian dari hutan negara merupakan suatu bentuk dari pengabaian terhadap hak-hak masyarakat hukum adat. Oleh karena itu, Mahkamah Konstitusi memutuskan bahwa hutan adat merupakan hutan yang berada dalam wilayah masyarakat hukum adat, jadi bukan lagi hutan negara yang berada dalam wilayah masyarakat hukum adat.
Selain itu, juga ada putusan berikutnya yaitu putusan yang berkenaan dengan hak asasi manusia atas air, di mana tepat pada tahun 2015, teman-teman, Undang-Undang Sumber Daya Air ini dinyatakan inkonstitusional secara keseluruhan oleh Mahkamah Konstitusi. Jadi, akses terhadap air ini merupakan bagian dari hak asasi manusia dan oleh karenanya, Konstitusi mengamanatkan hak penguasaan negara atas air. Putusan Mahkamah Konstitusi menegaskan bahwa Undang-Undang Sumber Daya Air ini tidak dapat menjamin terwujudnya hak penguasaan negara atas air karena itu dapat membuka peluang privatisasi dan komersialisasi pihak swasta atas pengelolaan sumber daya air. Privatisasi dan komersialisasi pihak swasta atas pengelolaan sumber daya air ini jelas merugikan hak konstitusional warga negara.
Nah, teman-teman, ternyata putusan MK ini monumental dalam melindungi dan memulihkan hak konstitusional bagi penghayat kepercayaan. Dalam Undang-Undang Administrasi Kependudukan dinyatakan bahwasanya kartu keluarga dan KTP elektronik memuat mengenai kolom agama. Namun, khusus bagi warga negara penghayat kepercayaan, ternyata kolom agama tersebut dikosongkan loh teman-teman. MK menyatakan dikosongkannya kolom agama di kartu keluarga dan KTP elektronik bagi penghayat kepercayaan ternyata telah menimbulkan diskriminasi dan kerugian konstitusional bagi warga negara penghayat ternyata telah menimbulkan diskriminasi dan kerugian konstitusional bagi warga negara penghayat kepercayaan terhadap Tuhan Yang Maha Esa. Menyatakan inkonstitusional ketentuan dalam Undang-Undang Perkawinan yang menyatakan bahwa anak yang lahir di luar kawin hanya memiliki hubungan keperdataan dengan ibunya atau dengan keluarga ibunya. Tentu saja ketentuan itu tidak memberikan perlindungan hukum bagi anak di luar kawin dong. Oleh karena itu, MK menyatakan bahwa anak yang lahir di luar kawin bisa memiliki hubungan keperdataan dengan laki-laki yang dapat dibuktikan dengan ilmu pengetahuan dan teknologi melalui tes DNA dari ayah biologisnya.
Nah, selanjutnya ada putusan MK yang dinilai memulihkan
Ladies and gentlemen, welcome back. Well, I think we are ready to continue to the fifth session of the short course. Well, the AACC members sharing experience will divide it into two parts. Part one will be moderated by Dr. Uz over there. Very excited, I think. And the second one will be led by Mr. Eri Satria Pamungkas. But firstly, we will start with the first part first. Therefore, for Dr. Uz de Lengen, please, the stage is yours.
Thank you so much. Good afternoon, ladies and gentlemen, distinguished guests. For those who don't know me, my name is Joost de Langen. I work for the University of Applied Sciences in The Hague. The Hague, also known as the city of the capital of peace and justice. We have the Peace Palace, as everyone probably knows. It's my great pleasure to moderate this afternoon's panel, where different members of the AACC, the Association of Asian Constitutional Courts and Equivalent Institutions, a mouthful, will share their experience. It is my great pleasure to welcome our distinguished speakers for today's session. We will open the session with Professor Jeffrey Epperson. Mr. Epperson is the President for International Relations at the National Center for State Courts in the United States. He works all over the world to help courts establish and improve judicial administration. And with over 30 years in different national and international positions, amongst which one in The Hague, he has a wealth of experience to share with us. Professor Epperson will share his perspective with us on successfully administering the transition to court electronic information management systems. After that, I will then give the floor to Mr. Hyo-Yoon Im from the Constitutional Court of Korea, who will talk with us about the role of Constitutional Court of Korea in expanding the opportunity for participating in the election. After him, Mr. Sherbek Izakulov from the Constitutional Court of Uzbekistan will share his experience on constitutional reforms in Uzbekistan. And third, last but not least, Mr. Kie Kin from Myanmar will talk to us about maintaining public trust to Constitutional Tribunal of Myanmar. Following their presentations, the session will be concluded by an open Q&A session. And at 2:15, I will be closing this session and invite you all to join me for a small coffee break. Before I yield the floor to our speakers and our first speaker, I would like to remind you all that we need to stick to the schedule. I was told that very deliberately. And uphold the time limits set for the presentations and the interventions by our distinguished organizers. Without further ado, it's my pleasure now to yield the floor to Professor Jeffrey Epperson to begin his presentation. Professor?
Thank you. Just give me 2 minutes when we're getting towards the end. Thank you, Sarah. It's a pleasure to be with everyone. It's also an honor to be on the stage with the Netherlands, which is almost like my second home country, having lived there myself. I hope everyone can hear me. I'm just coming here by way of Mongolia, where I met with the General Judicial Council and some of the new members there. And I just finished an assignment with the Supreme Court of Turkey, where we have just finished the commentaries on the international principles on judicial transparency, which I think many of your countries are signatories to. I haven't been to this conference before, and I've been learning a lot about, administration of what we call constitutional justice. And in my travels, I think I've been almost to every country represented here, and I've worked with your court systems in various capacities. I think particularly when I was the president of the International Association for Court Administration, and in that role I hosted several of your countries. I did want to talk a little bit about challenges. In my 40 years of experience, I've been working with the justice system. In fact, I feel like I'm a child of the justice system of the United States. I left service with the United States courts about 12 years ago to dedicate my career to establishing stronger systems of justice. I felt that my experience in the United States during our transition, I would call it a modern transition. We transitioned from a total paper environment to a total electronic environment over the course of my 31-year career with the federal judiciary. I also was had the opportunity while in the federal judiciary to serve on almost all of the committees of the Judicial Conference of the United States and several of our Chief Justices, particularly Chief Justice Berger and Rehnquist, and basically managing the governance of the federal judiciary of the United States. So I had the opportunity to manage budget cycles, IT cycles, financial cycles, personnel classification issues. And then when I worked at the United Nations Tribunal, I managed the Yugoslavia Tribunal. We were also introducing these modern principles into the system of the United Nations. There's one thing I noted while I was here, that I was raised on the Constitution of the United States, and I was raised to appreciate the values that are incorporated in that document. And I took an oath in my career several times to basically uphold the values of the Constitution of the United States. The second sentence of our Constitution is basically dedicated to the establishment of justice. That is the second sentence. And as I attend this conference and I hear about, challenges, to me, the challenge is not just to establish justice, it's to administer justice. And I think that's been one of our greatest challenges. The public, I believe, has a great hunger for more effective administration of justice. In fact, I think one of our greatest constitutional threats to these constitutional values is delay. The inability to reach disputes effectively, or dispute resolution effectively. And to me, jurisdiction is mostly not triggered unless there's a lower court decision. To me, there must be just resolution and reconciliation, but there must also be solutions. And those solutions have to capture, in my opinion, the modern trend of what I call productivity. In other words, particularly at the trial court level, the level of the first instance, in my opinion, is the one that we have to focus on first as a system. Why is that? Because the effectiveness of the trial court system, the system of the first instance, affects the workload of the whole system. For example, as we were talking about credibility and legitimacy and public perception, in my opinion, the ability of the trial courts to perform affects the workload on appeal, because the public must trust the legitimacy of the first instance court. It affects the process. And I want to talk to you a little bit about process today, because as I was responsible for managing several court systems in various capacities in several countries around the world. And in fact, we just established a new consortium of 8 countries that are experimenting with technology evolution that's based on what we call business development alternatives that are open source. In other words, being able to enabling court systems to develop systems in-house without the restriction of licenses, and also to be able to transition not just locally by administering systems locally, but using cloud-based approaches that will maximize the use of resources. And I think we all probably face a similar issue with workload. And workload is one of the greatest problems that we have. And so what I wanted to talk a little bit to you about is the importance of what I call modern design. And modern design is evolving. So just to give you a little bit of a anecdotal thought on my experience with electronic digitization and electronic transitions in my court, in one of my courts, over the course of 20 years, we reduced our budget requirements by 40% because we introduced electronic case management designs that were effective. And they reduced the requirement for personnel and space resources. And we can talk about that. But there are few challenges, in my opinion, that are greater than managing a national strategic transition to electronic management systems from a manual-based system based on traditional clerical support and paper. Having been directly involved in the management of national and local transitions, I sometimes imagined, basically, in fact, I'm going to be working with the Philippines soon on this whole process. I sometimes imagined being in a crucible fueled by stress, the stress of change. And we know how great the change management issues are. But for the hope for a better future for systems of justice. Of the nations that have experienced this crucible, some have succeeded in managing the transition and others have failed. Ultimately, change in managing a transition like this entails great risk, but more importantly, great gain. And in my opinion, and having worked with the systems, if the arc of the moral universe is to bend towards justice, perhaps automation can help us bend that arc. For many, this goal is why we work long hours for low wages, because we want to raise the levels of dignity and achieve equal justice under law for the people, one generation at a time. Every transition, in my opinion, must start or have started with a strong strategic plan and a strong core mission statement outlining the vision of a project. A vision partly based on what I've talked about so far. But there's an ultimate goal that has to be contemplated for every court or national transition. And I found this when I managed this transition at the Yugoslavia Tribunal for The Hague. To achieve to achieve uniform and total digitization within a country or within a court system, there's one goal that has to be considered. It was the key. You have to be able to legislate the authentication of the electronic record as the original. And you have to be able to utilize the digital signature in the place of the manual signature. Until you authenticate the electronic record, you will have two records because the paper is still authentic. So it's something that I realized that until we achieved that strategic goal of authenticating the electronic record, we actually increased the resources needed to manage the court. So I just wanted to bring that up to you as, to me, one of the key strategic goals. I wanted to talk a little bit about addressing cultural change. And for me, in a way, I'm working with an institution to my right that are experts in what I call the management of applied experience. And it's not just talking about it, it's about doing it. learning from experience, in my opinion. And I went through a transition where I almost lost my job several times because of the risk and the changes that have to be introduced in cultures to adapt to electronic transitions. So in a way, in the United States, 30 years ago, I had the first court in the country that implemented a website. And those websites became what I call a virtual court. So now, in the United States, over the course of our 30-year history, our courthouses are no longer physically located. They're virtually located. And it took a while to adjust to that new dynamic. But when you go on to the United States courts websites, and you'll see filing, the record, all information, all of our calendars are there. And the other thing that's there is basically the instructions on how to utilize our virtual court services. So as you know, we went through a pandemic that very few of us were ready to manage remotely. I mean, who had a continuing operations plan that envisioned the pandemic? I don't know. I've done a lot of continuing operation plans in my career. None of them probably addressed the urgencies of the pandemic. In fact, as I look at the results of the pandemic, and as I travel the world and I see those results being defined by backlogs, and not only in many countries was delay bad, now it's worse. And what was one of the biggest problems during the pandemic for judges and for the attorneys and for the staff? They had to keep coming to the office or it didn't get done because they didn't have the remote capacity to manage the services before the pandemic that were required during the pandemic. So I know we had to adjust to those challenges. We've all had to adjust to those challenges. What was one of the greatest challenges to the judges and the lawyers? They were trying to work from home, but they didn't have the record. The record was not digital. Now, even in my country, we had the record at home. We had the record in Europe. You could get the record in the whole world. So you could hold hearings with the record and with the evidence mostly remotely. So you had a digital jurisdiction. But most countries, I believe that challenge still remains strategically of creating a digital record that will facilitate remote trials and hearings. The other thing that I learned during an electronic transition, we have to remember the quality of the trial environment and our goals. I believe remote digital hearing services, let's call them Zoom or Microsoft Teams or whatever platforms we're using, are effective to a degree. I believe that the most effective utilization we've learned of digital services are non-dispositive hearings, which are basically the processes up until the dispositive portion of the trial where you have an adversarial process that becomes more engaged. And we have found that while technology is good, the administrative requirements are still great remotely. It's not just about the system, it's about the people that have to support the system. And many of us know that every day I have a problem with a remote hearing because I need technical support to help me fix problems to get the hearing administered. So we have found that, the dispositive, non-dispositive paradigm is an important issue. So how much more time? 2 minutes? 2 minutes. So I just wanted to raise some of those points with you. And I also wanted to talk a little bit about the case management system as we think about it in the future. And I want to talk about time. Time. I have learned that building professional capacity in the area of information management and support is critical. It's no longer clerical. We used to think of terms of court management as largely clerical management. Now, when you combine the requirements of technology with the importance of introducing, virtual management of hearings, it's important to have management capacity that understands how to re-engineer process and map it to the digital age. That's the key, is managing the transition. How many judges are trained to manage? But building that management capacity and understanding the technical requirements and managing that capacity and the human resource and budget requirements are critical. One more thing on budget. My last comment, I'm just kind of giving you some of the highlights of my experience, which you probably had, and I'm probably speaking to the choir, and that is budget management and sustaining the budget over time. I worry because if we all study the principles of OECD, the Organization for Economic and Cooperative Development, there are management principles on budget and finance included therein that are accrual-based. And that accrual approach to managing the budget means that you can plan and execute from day one of the fiscal year and not day 360. And I think understanding that budget management approach to executing strategic planning for technology is critical to sustaining cyclical maintenance. And cyclical, the other beauty of paper was that your cyclical maintenance was basically the retirement of people every 20 to 30 years. Now, it's about retiring systems every 3 to 4 years and how to manage that cycle. All these are very just what I call critical, complex, but that's just some of my thoughts. I had a long paper that you can read online. I realized that I'll just hit the high points with you, but I just wanted to say it's a pleasure to be with all of you and look forward to our commentators from the other countries. So thank you very much.
Thank you, Professor Epperson. I wanted to ask for a warm round of applause, but you beat me to it. As mentioned, please hold on to your questions later. I can imagine you have a lot of questions for someone with this wealth of experience. But we need to continue. To proceed, may I invite Mr. Hyo Yoon from the Constitutional Court of Korea.
Thank you. Good afternoon, everyone. I am Hyo-jun Im, the Rapporteur Judge of Constitutional Court of Korea. It's a great honor to have an opportunity for sharing our experiences with other AACC member states. And I sincerely appreciate the Constitutional Court of Republic of Indonesia for providing this meaningful conference. The Constitution of the Republic of Korea provides that all citizens shall have the right to vote in Article 24 and the right to run for public office in Article 25. The Constitutional Court of Korea, since its establishment in 1988, has proactively reviewed the constitutionality of the various aspects of election law. Its decisions have far-reaching ramifications insofar as the election law has moved in a more democratic direction and reinforced representative democracy in Korea. Especially the court has been playing a crucial role to protect the right to participate in election. Today, I'd like to address several major decisions of the court in two parts, all of which expand the people's opportunity for participating in election. The first part is about enlarging the subject of right to vote. In this part, I will treat two major decisions. The first decision is on the right to vote of nationals residing abroad. In 2007, the court declared that the provisions which do not grant overseas Korean nationals the right to vote are not conformable to the Constitution. The court pointed out that exercising the right to vote functions both as an important channel to reflect people's wishes upon state affairs and as the means to control over state power via periodical elections. That is why the right to vote are considered to hold the supreme status over other fundamental rights in order to realize the principle of popular sovereignty. In this regard, the court held that putting any restrictions on the right to vote can be justified only when there exist an inevitable, particular, and certain reasons to do so. However, the provisions at issue have no just legislative purpose, therefore violates the right to vote, right to equality, and the principle of popular election. Especially in this international era where more and more Korean nationals emigrate to foreign countries, the fact they have emigrated voluntarily cannot be a justifying reason to deny someone from exercising the right to vote. Reflecting the intent of the above ruling, in 2009, the Public Official Election Act adopted an overseas absentee voting system and an overseas election system for presidential elections and National Assembly elections. As a result, Koreans living overseas can vote. Koreans living overseas were allowed to vote at overseas polling stations. Second case is on the restriction on probationals and prisoners' right to vote. In 2014, the court ruled that it is unconstitutional to restrict the right to vote of probational, a person for whom an execution of sentence is suspended, and it is unconformable to the Constitution to restrict the right to vote of prisoners, a person who was sentenced to imprisonment for a limited term and whose sentence execution has not been terminated. The court emphasized that today, elections are the most important means for the people to exercise their sovereignty in a representative democracy. By exercising voting rights in the election, the people provide democratic legitimacy to state institutions elected through election and the exercise of their state powers. Therefore, the legislature should enact laws that guarantee the right to vote to the fullest extent, and the court should apply strict scrutiny in reviewing the constitutionality of laws that restrict the right to vote. The court held that even if it is necessary to restrict the offender's right to vote, it is against the rule of least restrictive means to restrict the right to vote of both prisoners and probationals without considering the gravity of offenses, intentional negligence, the nature of legal interest infringes, etc. So the provisions at issue infringe the right of probationals and prisoners to vote. Reflecting the intent of this decision, the National Assembly amended the Public Official Election Act in 2015 and provided that a person who is sentenced to imprisonment for less than 1 year and is still under such sentence, and person who is given a suspended sentence shall be entitled to vote. Now let's move on to second part. The second part is about guaranteeing more opportunity for running for public office. I also treat two major decisions in this part. The first case is about the deposit money in elections. The court delivered decisions of non-conformity to the Constitution 3 times from 2001 to 2016 regarding the provisions on the amount of money to be deposited for elections. At the time of its decision, the Public Official Election Act required candidates for a presidential election to pay a deposit of 500 million Korean won, approximately 350 $1,000 for election of members of National Assembly to 20 million won, and for election of proportional representation members of the National Assembly to 15 million won. In these cases, the court held that the legislative purpose of deposit money in election lies with preventing many insincere and indecent candidates from applying for registration. However, the deposit money should not be set at a notably excessive or unreasonable amount. The amounts of each case are very large sums that cannot be procured easily by average citizens without taking out loans or receiving donations, unless he or she is very rich or recommended by a major political party. Consequently, anyone who cannot raise such an amount will be effectively barred from running for public office, even if the person were to be the most qualified candidate. Furthermore, the court added that the provision on deposits for proportional representation National Assembly member candidates sets the same amount as for local constituency National Assembly member candidates is deemed as excessive. While local constituency member elections are by nature elections of individual persons, but proportional representation member elections are those of political parties. So the election is so much less likely to bring about corruption or overheating through election campaigns. And as newly formed parties or minor parties find it difficult to secure even one seat, requiring such parties to pay deposit in proportion to the number of candidates would be excessive, having a daunting effect on their participation in the proportional representation elections and recommending candidates. After these decisions, the Public Official Election Act lowered the amount of deposit required to register. So now 300 million won for presidential elections and 15 million won for elections of constituency members of National Assembly and 5 million won for elections of proportional representation members of National Assembly. And the second case and the last case is about the cancellation of political parties registration. In 2014, the court ruled that the provision requiring the cancellation of registration of political party which fails to obtain any seat and at least 2% of the total number of effective votes in the National Assembly election is unconstitutional. The court stated that, given the importance of political parties in the representative democracy, any restriction on the freedom to form a political party should be as minimal as possible. Particularly, any provision that stipulates the cancellation of political parties registration should be legislated on a strict standard within the necessary minimum scope, because it deprives a political party of its existence and makes it impossible for the political party to conduct any kind of political activity. The court stated that it is hard for a newly established political party to attain a high level of political support from the beginning. In this context, the court acknowledged that the existence of less restrictive means, for instance, the cancellation of party registration can be decided either depending on the result of election after several chances to participate in public officer elections for a certain period of time.
1 minute.
Yes, I've just covered almost all the materials I prepared for today's presentation. And I hope that our experiences shared today will help other AACC member states to deal with the similar cases. Our court provides the full text or summary of all the decisions I covered today through English version website. And if you need to learn more about the decision, please visit our website and check the detailed. And thank you very much for your attention.
Thank you. Without further ado, I would like to give the floor to Mr. Sherbek Izakulov from the Constitutional Court of Uzbekistan.
Thank you. Thank you. Dear colleagues, ladies and gentlemen, let me welcome you and also thank the organizers of today's event, the Constitutional Court of the Republic of Indonesia, for the invitation and opportunities to speak to you. We believe that holding of 5th Congress of World Conference on Constitutional Justice in Indonesia demonstrates the Constitutional Court of Indonesia will contribute greatly to strengthen cooperation between constitutional courts around the world. I would like to take this opportunity to briefly inform the participant of our today's event about the work we have done to improve the legislation of the Republic of Uzbekistan to ensure the independence and autonomy of the Constitutional Court and the development of constitutional review in our country. From the first days of independence, the Republic of Uzbekistan set its first task to establish the democratic state governed by the rule of law as proclaimed in our constitution. In the recent years, Uzbekistan has reached the entirely new stage in the development and had made significant progress along the way. The current course of Uzbekistan is aimed at ensuring the full protection of human rights and laying foundation for the new Uzbekistan. It should be noted that this year marks the 30th anniversary of Basic Law, which was adopted on December 8, 1992. In the 30 years since the adoption of Constitution, tremendous changes have been made in our country. This concerns the modern technology, living standards of our citizens, sustainability of national economy. The country needs to move forward using this enormous potential. These and other factors necessitated serious amendments. In this regard, the President of the Republic of Uzbekistan came up with initiatives to carry out constitutional reforms. The following priority areas of constitutional reforms has been identified. First, the changes from the previous operating paradigm, state, society, person, has now changed to a person, society, and state. It considers the importance of human being in Uzbekistan. The second is ensuring human interest in process of economic reforms. The third, constitutional consolidation of role and state of civil society and institutions. The fourth, the definition of constitutional foundation for development of institutions of family, careful transition of traditional human values to future generations, and strengthening of inter-ethnical harmony in the country. Fifth, the reflection in the constitution of the state youth policy, comprehensive support of young people, their rights and interests, and their duties. The sixth principle of New Uzbekistan in social state has been entrenched as constitutional norm. Seventh, the increasing effectiveness of current system of human rights protection, preventing child labor, reliability of health care, representative of protecting of older generation. At the first stage of Constitutional Commission, work on amendments in addition to the basic law, studied proposals and comments, and then drafted constitutional law and submitted to the legislative chamber of Oli Majlis of the Republic of Uzbekistan. The second stage of constitutional reform provides the submission of the draft law for public discussion. The draft amendments to the Constitution have been put up for public discussion, which was held until August 1st, 2020. The third stage is holding the referendum, which will allow to find out attitude of people to the proposed reforms. It should be noted that constitutional reforms can be an important tool to promote better governance by amending constitutional provisions that strengthen the system of checks and balances between the branches of the government. This is achieved primarily through the clear distribution of power between the President, Parliament, government, and formation of proper balances in the system of separation of power, strengthening the checks and balances, and the development of civil society. As as is known, the effective implementation of such basic principles of democracy as supremacy of constitution, protection of fundamental human rights, freedoms, depends on a large extent on effectiveness of institutions of constitutional reform. Over the past period, a solid legal basis for constitutional control has been established in our country. Constitutional legislation has been improved and the effectiveness of constitutional justice has been increased. The legislation of Uzbekistan did not provide a possibility for citizens to submit issues of consideration by the constitutional courts. The citizens has also indirect access to constitutional justice. These and other factors promoted the adoption of a new law. On April 2001, the Parliament of Uzbekistan adopted a new constitutional law on the Constitutional Court of the Republic of Uzbekistan, the development and adoption of which was provided for by the National Human Rights Strategy of the Republic of Uzbekistan. This act reflects new provisions to ensure the further development of constitutional reform. The circle of subjects with the rights to submit the issues on Constitutional Court is further extended to National Center for Human Rights, Commissioner under the President of the Republic of Uzbekistan for the protection of rights and legitimate interests of business entities, Business Ombudsman, the Commissioner for Child Rights, the Juvenile Ombudsman, and the new law provides that citizens and legal entities have the rights to apply Constitutional Court with complaints about the review of constitutionality of the law if they have believed that the law violates their constitutional rights and freedoms, is inconsistent with Constitution and applied in a specific case where the court proceedings have been completed and all judicial remedies have been exhausted. It's known that the significance of the institution of constitutional complaints is not limited to ensure the rights of citizens to access the constitutional justice, but also serves as a legal mechanism to improve the quality and effectiveness of law, to ensure their constitutionality. The use of institute of constitutional complaint contributes to the development of doctrine of constitutional legality and the protection of fundamental rights and freedoms of citizens. Granting the citizens the right to challenge the constitutionality of law contributes to the development of democratization of society and observes the rule of law in the country. The new law enshrines to provision the legal nature of constitutional judgments. The decision of the constitutional court are final and not subject to appeal. The decisions of constitutional court are obligatory for all state bodies, public associations, enterprises, institutions, organizations, officials, and the citizens. Normative legal acts or their separate provisions recognized as unconstitutional lose their legal force. A preventative form of constitutional reform have been introduced. Those the law enhanced the constitutional court with the task of demonstrating the compliance with Constitution of the Republic of Uzbekistan. The right of citizens to bring the matters before the Constitutional Court leads to sharp increase in the workload of the court, taking into account the foreign experience as well as connections with the introduction of institution of constitutional complaint. The composition of Constitutional Court of the Republic of Uzbekistan has been increased by 2 people and now has been set to the amount of 9 justices. We used to have 7 justices before.
1 minute.
Yeah. the procedure for formatting the Constitutional Court has been more democratic. The Constitutional Court is now elected by the Senate upon the proposal of the President from among the person recommended by the Supreme Court of the Republic of Uzbekistan. In conclusion, I would like to note that ongoing constitutional reform and implementation of new constitutional law on the Constitution of the Republic of Uzbekistan contributes to increase effectiveness of constitutional juridical control in our country. Thank you for your attention.
Thank you. And then we go on to Mr. Kiki Kin from Myanmar.
Thank you. Good afternoon, moderator, other participants of the AACC, ladies and gentlemen. We have a great honor and to be with you this moment time for representing of behalf of Myanmar attending this event. First of all, to take this opportunity, we would like to express our gratitude to the Indonesia Constitutional Court for the invitation to Myanmar to attend this short course. We believe that the upcoming sessions of short course will begin its success under great effort of leadership. Mr. Moderator, all the participants of ladies and gentlemen, Myanmar launched a new chapter, the democratic transition, under the 2008 Constitution. The 2008 Constitution was ratified and promulgated by the National Referendum on May 29, 2008, being approved by 92.48% of these people of Myanmar who support the draft constitutions. It came into operation throughout the Union on the day of the first session of Parliament was convened. The 2008 Constitution defined the basic structure of the government and made some commitment to the rule of law, including the separation of power between the three branches of sovereign power and setting out 5 constitutional rights available to challenge violation of individual rights. As the democratic transition takes hold, Myanmar is moving from rule by law to rule of law. Our Constitution provides that basic principle of the Union. Each chapter enumerates structure, judicial principle, political, social, and economic rights, and the setting of the Constitutional Tribunal. Section 19 of the 2008 Constitution states the judicial principle. Moreover, it is required that every citizen shall enjoy the rights of equality, the rights of liability, and the rights to justice as required in the 2008 Constitution. Mr. Moderator and all the participants of ladies and gentlemen, we may say that the only and merely legal document reinforced protection in Myanmar is the 2008 Constitution. Chapter 8 of the 2008 Constitution enumerates several fundamental rights, including various protection against discrimination, rights to education and healthcare, language and other cultural rights, prohibiting on enslavement, people trafficking, and forced labor. Rights to property and privacy, the rights to vote and stand in election, and freedom of expression, association, freedom of movement, and belief. The Supreme Court expressly authorized under the Constitution to issue 5 different types of writs in case of infringement of the fundamental rights by unlawful conduct or decision by the executive, public, administrative, and judicial authority that are outlined with exactly. Every country safeguards its citizens' rights, and most nations protect their democratic value according to their political policy. Mr. Moderator, and all the participants of the ladies and gentlemen, Start this portion, we would like to express the Constitutional Tribunal of the Union of Myanmar, its power as follows. Interpreting the provision of the Constitution, evaluating or scrutinizing the law enacted by the legislative body in conformity with the Constitution or not. 3. Validating the measure of the executive authority in conformity with the Constitution or not. 4. Deciding the constitutional disputes between different levels of the government. Furthermore, any court is able to refer to the Constitutional Tribunal through the Supreme Court of the Union with regard to the constitutionality of law under Section 323 of the 2008 Constitution. Our Constitutional Tribunal is the judicial institution particularly established to safeguard the Constitution in the event of infringement fundamental principle by the legislature of executive. It is only the judicial institution vested with the power to decide on the constitutionality of law and the related constitutional matter. Although all the infringement of the fundamental rights of the citizens are constitutional matter, the Constitutional Tribunal does not have the power to deal with those fundamental rights of the Constitution. Mr. Moderator, or the participants, most of the constitutional courts in the world have the jurisdiction to protect individual fundamental rights. Although the Constitutional Tribunal of Myanmar have no direct jurisdiction to protect such rights, but dealing with the interpretation of the provision of the Constitution and having the power of adjudication or constitutionality tests of any existing laws. By the way of its function and power, that is interpretation, opinion, and constitutional dispute resolutions. The Constitutional Tribunal has the power to protect fundamental rights. The Constitutional Tribunal has the power to explain and scrutinize the law in conformity with the Constitution. If a law is inconsistent with any provision of the law, it is declared null or void. Moreover, the Constitutional Tribunal has the power to vet whether the measure of the executive authority of the Union, the region, and states are in conformity with the Constitution or not. That the Constitutional Tribunal can declare the act of the executive null and void if they are found to be in conflict with the provision of the Constitution. State institutions and citizens must have wide knowledge about the tribunal and how to exert in their pursuit of justice. To get public recognized and trust judicial institution of the Constitutional Tribunal, particularly the individual how to know how to obtain access to Constitutional Tribunal. Therefore, the Constitutional Tribunal trying to disseminate information about its role, function, and decision-making to raise public awareness. The Constitutional Tribunal has been planned an ecosystem and electronic filing system for proceeding for submitting to the Tribunal. The resolutions of the Constitutional Tribunal must be enforced and financed and conclusive. Furthermore, the resolutions are being decided in accordance with the Constitution and existing law. To conclude our presentation, we would like to say that our Constitutional Tribunal should try its best to get more public recognition and trust in line with its legitimate power under the Constitution and existing law. Thank you for your attention.
Thank you. To conclude, to everyone, dear participants, may I invite you to address your questions to the different speakers. Who's first? Sahani.
Thank you very much, Josh. I want to ask to Professor Epperson. One of the big issue in Indonesia related to the court budget problems. You see that Indonesia Constitutional Court, if we want to take some budget, we must make some proposal to the parliament and also to the president. And it's clear, it's disturb our independency. How we handle about the issue? Because each year, our Secretary General must send proposal to the parliament and to the president to approve our budget. That's one issue.
And the president?
Yes, also the president.
Oh,
okay.
Okay.
So both must approve the budget.
Yeah.
Okay. Another issue is about supervision of the judge. Do you think we must have a supervisor body for the judge? Because in Indonesia we have a judicial commission, but it's just supervise the Supreme Court judge, not Indonesia Constitutional Court. Not constitutional judge. I need your opinion about this issue. Thank you.
Both issues? Two issues.
Both issues. Thank you.
The second issues, they're both very difficult issues. I served on the budget committee of the Judicial Conference, which basically managed the appropriations process. And we used to have what I would call, we had a budget committee. And that budget committee drafted the budget for the judiciary. Now, we had a little bit of a different process because the president could not comment on our budget. So there was a rule. The legislature, however, could review it closely. So one way we approach budgets in Congress in the United States are approved based on need. So we have to establish need first. We developed an approach on establishing need wherein we created workload formulas. And those workload formulas were based on personnel needs, space needs, and IT needs. In other words, we did studies to establish these need-based formulas. Congress approved the formula. So once we established the need-based formulas, it made the negotiation process less difficult. And then there's the political side to the process. And what we all face as judiciaries is we have to be very careful about utilizing political friends. What came up today? We have to be very careful about our relationships. However, we know that in the United States, the legislature is the key component of the appointment of the judges. And they usually have, let's just say those existing relationships aren't used anymore, but they're there. And it facilitates the negotiation process, even though you cannot act on those relationships. That was a key component, I think, of our approach. But to me, it was the need-based formulas that were critical. The other thing is, it's not just about the appropriation, it's about the use of the appropriation. And many countries, because of their procurement processes and their budgeting processes, are not able to fully utilize the appropriation by the end of the year. Now, one thing that we did, we established, particularly for IT, because of the cyclical maintenance requirements, no year accounts. No year accounts. Multi-year accounts. In other words, an appropriation not just for 1 year, but for 5 years. That is a key, what I would consider strategic consideration. So that's the best I can say, but it is a process, it can be managed, but we're always going to get less than what we ask for. The question is, how do we use the less? That's the question. That's where we have to be smarter about utilization. As to supervision of judges, I just left Mongolia, where they've established an independent judicial discipline committee. And, we're studied in the United States how to best manage conduct and performance. And it's very difficult when those that are responsible for supervising conduct are also subject to those same rules. In other words, there's no separation regarding the supervisory approach to managing conduct within the judiciary. I think ultimately that independent committee, discipline committee approach that has to be protected from politicization is one consideration. Other countries call it an ombudsman. But that ombudsman approach, in my opinion, needs to be studied. I do know that we've been accused of having ethical concerns ourselves in the United States. However, I have great confidence in our judiciary. However, the public perception of not having the independent supervision has always been a problem for us. So there are solutions, but sometimes the solutions can become bigger than the problems, because ultimately we do want to protect judicial independence. There's nothing more important than judicial independence. But the other thing we have to worry about, and somebody brought up the Bangalore Principles, and I'm on a work group on the Bangalore Principles. We have to reinforce when we're training judges, we have to reinforce the importance of accountability. And while the Bangalore Principles cover propriety, they don't really focus on the attributes of accountability that are the key, to me, platform to independence. Is the public has to understand repeatedly that accountability is as important as independence. I think that's something that we have to grapple with. It can come in the form of training, it can come in the form of policy revision, but we ultimately have to think about that supervisory role more clearly. But it's a balance because of the separation of powers, I think. So.
Thank you, Professor. Any other questions? If not, then I would like to thank all of our distinguished speakers for sharing your experience and your knowledge with us, and also the discussant, in this case, for sharing your thoughtful comments. And I'd like to conclude and invite you all for a coffee in the lobby. Thank you.
Thank you, speakers, moderator, and the representative from the Aacc members as well, and discussants. And now it's not yet for coffee break. We will continue. We will continue then to the second part, ladies and gentlemen. So, without any further ado, I would like to invite our moderator to guide the session. Please welcome Mr. Eri Satria Pamungkas. Please, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh, and good afternoon, friends, colleagues, and participants of the Constitutional Court international short course of the AACC in 2022. And because we are running out of speakers, so this time I choose to invade the VIP space to become moderator here among you all, because I also like to use this opportunity to introduce you to some of my supervisors. And beside me, we have the Registrar of the Constitutional Court, Mr. Muhyiddin, and I also have the distinguished Deputy Registrar of the Constitutional Court, Ibu Ida Ria Tambunan, and also another Deputy of Registrar of Constitutional Court of Indonesia in my side, also Bapak Triyono Edi Budiarjo. And this is almost the complete formation of the Registrar Office of the Constitutional Court of Indonesia. And also beside me, we have also fellow, almost all substitute registrar of the Constitutional Court of Republic Indonesia. Thank you for coming, and thank you for supporting this, this session and this short course. And finally, we have reached the final session of this short course, and we will complete this session with another session of AACC members sharing experience. So I would like to invite each delegate to share their presentation experience or expertise, and according to the program, we get at least delegates from 5 countries of our institution, which are one, Ms. Nigora Maripova from Kazakhstan, and the second is Mr. Selçuk Kilik from Turkey, and third is Ms. Dulam Soron Dastondok from Mongolia, and the fourth is Ms. Sumaporn Srimong and Mr. Sakumpong Tri Sampong from Thailand, and last but not least, the attorney Maria Patricia Valena and Ms. Micha Celine Carpio from the Philippines. And of course, I expect that each delegate have already prepared a short presentation or some resume of their paper without leaving the substance behind, because I have to remind you that each one of you will have time about 10 minutes to deliver your presentation. And after that, of course, I will give opportunity to other participants to ask question or clarification or any other issues to discuss related to their papers, to any presentation from any delegates. I want to remind you that consider this session as your best opportunity to obtain as many information as possible from fellow participants, and hopefully you could create transformation or positive transformation in your institution after this event. And without further ado, I would like to start with the first presentation. Is from Kazakhstan, which will be delivered by Ms. Nigora Maripova. Please, Ms. The floor is yours.
Thank you, sir, so much. Dear participants of the short courses, first of all, I would like to express my gratitude for the outstanding organization of these short courses and other events in the frames of the 5th Congress. My thanks to the Constitutional Court of Indonesia. Today we are going to speak about the elections, and the topic that we are discussing today is very relevant. On November the 20th, the citizens of Kazakhstan will have to choose the President of the Republic, which means new initiatives aimed at the socio-economic development of the country. I will speak today about the decisions of the Constitutional Council, which contribute to the improving of the electoral legislation in the Republic of Kazakhstan. Nowadays, it is difficult to overestimate the place and the role of elections in the functioning of the democratic state. Elections are a necessary condition for democracy and a kind of mechanism that allows citizens to participate in political life and management of state affairs, to maintain or change parliaments and governments, to ensure their responsibility to the people, to change the political course. The institution of presidential and parliamentary elections in a special system forming constitutional value is a special system forming constitutional value, which acts as an effective means of updating the most important organs of the state. This strengthens the social basis of the republic, the support of the population for the initiatives and of the state authorities. By voting at the Republican referendum or at the elections of the President of the Republic and deputies of the Parliament held periodically in the country, the act of expression of will of the people, being one of the fundamental constitutional values, acquires binding legal force. According to the Article 3 of the Constitution of the Republic of Kazakhstan, the only source of state power is the people. The people exercise powers directly through a Republican referendum and free elections, and also delegate the exercise of their power to state bodies. That is, by directly participating in the Republican referendum, the elections of the President, the formation of the Parliament, local representative bodies, the people exercise their powers. The Constitutional Council determined the significance of these constitutional provisions as laying the political and legal foundations of an integral system of democracy for the subsequent consolidation and regulation in the basic law of relations between direct and representative forms of democracy. The status of a citizen of the Republic of Kazakhstan, including his right to participate in the management of state affairs directly and through his representatives, as well as the purpose, the order of formation, functions, competence, and responsibility of the high state bodies of the Republic, their relationship in the mechanism of checks and balances. In democratic states, the process of elections to state bodies is regular and permanent. The same can be said about our country. The terms and procedure for holding elections are determined in accordance with the Constitution and the constitutional law on elections. The legislation of Kazakhstan established the following regularity of elections. Every 7 years, the President, every 6 years, deputies of the Senate, every 5 years, deputies of the Majlis, it's the lower chamber of the Parliament, every 5 years, deputies of Maslihats of all levels, and every 5 years, the governors of districts and cities of regional significance. As I noted before, the people of Kazakhstan exercise their power directly through elections and referendum. Therefore, it is very important to ensure the constitutional basis for holding elections and referendum. And when controversial issues arise about the constitutionality of the elections or referendum, it is necessary to solve them effectively. One of the main mechanisms for ensuring constitutionality in the exercise of power by the people of Kazakhstan is in accordance with paragraph 1, Article 72 of the Constitution, consideration by the Constitutional Council in case of dispute, the issues of correctness of the elections of the President, of the deputies of Parliament, as well as Republican referendum. According to the Article 733 of the Basic Law, if a subject of constitutional proceedings appeals to the Constitutional Council on one of these issues, the inauguration of the President, registration of elected deputies of Parliament, or summing up the results of the referendums, respectively, are suspended. These provisions were further developed in the constitutional laws on elections and referendum. Thus, according with the Article 768 of the election law, on an appeal on the correctness of the elections of the President of the Republic may be submitted to the President of the Republic by the President of the Republic, the Chairman of the Senate, the Chairman of Majlis, at least 1/5 of the total number of deputies of Parliament, the Prime Minister within 10 days after the election results are summed up. An appeal to the Constitutional Council appeals the suspension of the assumption of the office of the President of the Republic for the period of verification of the correctness of the elections. The issue of correctness of the elections of deputies of the Senate is considered by Constitutional Council on appeal of the President of the Republic, Chairman of the Senate, and Majlis at least 1/5 of the total number of deputies of the Parliament and Prime Minister, and also can be submitted within 10 days after the election results. It should be noted that according to the paragraph 3 of the Article 73 of the Constitution, the Constitutional Council makes its decision within a month from the date of receipt of the appeal. And at the request of the President of the Republic, it can be reduced to 10 days if the issue is urgent. In practice, the Constitutional Council haven't so far considered the disputes on the correctness of the elections. However, during its activity, various specific aspects of the country's electoral system have repeatedly become the subject of consideration by the Constitutional Council, and various aspects of passive and active suffrage have been officially interpreted. And below I will give some examples of the legal positions of the Constitutional Council on electoral law issues. As the society has been reforming, the democratization of electoral processes took place systematically, and the legislative framework was improved. Amendments and additions have been made into the election law, the norms of which establish various measures that contribute to the proper realization by citizens of their right to participate in the management of state affairs directly through free elections. Reviewing the constitutional law on amendments and additions to the Constitution to the constitutional law of the Republic of Kazakhstan on elections. For compliance with the Constitution, the Council analyzed the issues of electoral law concerning the restriction of a citizen's right to be elected on the basis of a criminal record that has not been extinguished or removed by the time of registration, as well as the issues of electoral process, namely changes in the principles of formation, territorial, district, and precinct election commissions. Article 33 of the Basic Law indicates who among the citizens of the Republic and for what reasons is excluded from the electoral corps, so has neither active nor passive electoral legal personality and does not participate in elections. Thus, the right to elect and to be elected to state bodies and local self-government bodies, as well as to participate in the referendum, is granted only to the citizens of the Republic of Kazakhstan and indicates that citizens recognized by the court as incompetent, as well as those held in places of deprivation of liberty by a court verdict, do not have the right to elect and to be elected, participate in the Republican referendum. In its decision, the Constitutional Council indicated that the requirements of the Constitution for citizens of the country exercising passive suffrage are much higher than the rest of the majority of voters, since they have to bear the burden of legislation and state decisions. This imperative of the law follows from the first constitutional duty of everyone to observe the Constitution and legislation of the Republic of Kazakhstan and to respect the rights, freedoms, honor, and dignity of other persons. The fact that the criminal record has been withdrawn or extinguished in accordance with the procedure established by law should not prevent a citizen from exercising his right to be elected. The Constitutional Council considers the requirements of the constitutional law justified since they are aimed at protecting those constitutional values in the interest of which the Basic Law allows restrictions on the rights of citizens. They meet the objectives of protecting constitutional order, maintaining public order, human rights and freedoms, public health and morals, and are not discriminatory on the basis of race, skin color, gender, language, religion, or social origin as required by the International Covenant on Civil and Political Rights. These imperatives equally apply to all citizens of the Republic who have expressed a desire to run for elections to representative bodies or the post of president. In another regulatory resolution on the official interpretation of paragraph 3 of the Article 41 of the Constitution, regulating the right of the President to appoint early presidential election by his own decision, the Constitutional Council indicated that the President of the Republic is the only personified supreme representative of the people of Kazakhstan elected by adult citizens of the Republic on the basis of universal, equal, and direct suffrage by secret ballot. So Constitutional Council decided that the appointment of early presidential elections aimed at ensuring constitutional values as well as the fundamental principles of the Republic, activities, social harmony and political stability, economic development for the benefit of the people, Kazakh patriotism, in accordance with the Basic Law, is exclusively within the competence of the President of the Republic. There are some other regulatory decisions of our Council, but I'm pressed for time. That's why I will conclude my presentation. Thus, the implementation of preliminary control in the field of legislation relating to the aspects of the electoral system as well as the other official interpretation of the various aspects of passive and active electoral law in the context of improving the procedures of citizens' influence on public institutions also serves as an effective guarantee of internal stability, economic progress, and improvement of the welfare of the population. And I would also like to inform you, dear participants, that Kazakhstan is currently undergoing large-scale constitutional reforms that have affected the constitutional and legal system of the country. In this direction, a serious innovation in the transformation of the Constitution is the transformation of the Constitutional Council into the Constitutional Court, with expansion of the list of subjects of appeal. It also includes the Prosecutor General, the Commissioner of Human Rights. The Constitutional Court will consider citizens' appeal for verification of compliance with the Constitution of normative legal acts directly affecting their rights and freedoms. Currently, a draft constitutional law on the Constitutional Court has been developed, and the Constitutional Court will start functioning on January the 1st, 2022. Thank you for your attention.
Thank you, Ms. Maripova. And the second one is from Mr. Selçuk Kiliki from Turkey. Please, sir, the floor is yours.
Thank you. I would like to extend you all my most sincere greetings, and I would like to thank everyone for the invitation and for their contribution to this great organization. The Constitution Court of the Republic of Turkey has been entrusted with various duties by the Constitutions of 1982. Among these duties, each of which is significant, constitutionality, review, and individual application have a special and privileged place. With the Constitutional Amendment 2010, the Court was also entrusted inter alia with the duty to examine individual applications, and it has been receiving individual applications since 2012. Individual application mechanism has been one of the most important recent judicial reforms in Turkey. The rights and freedoms falling within the joint protection realm of the European Convention on Human Rights and the Turkish Constitution constitute the subject matter of individual application. Everyone, either citizen or foreigner, has the right to individual application. It may be said that with the introduction of the individual application mechanism, the court has attained a stronger and privileged position in terms of ensuring constitutional justice. In Article 5 of the Constitution, the following duties are listed among the duties assigned to the state: to ensure the welfare, peace, and happiness of the individual and society, to strive for the removal of political, economic, and social obstacles which restrict the fundamental rights and freedoms of the individual in a manner incompatible with the principles of justice and of the social state governed by rule of law, and to provide the conditions required for the development of the individual's material and spiritual existence. Today, the court acknowledges that these duties can only be fulfilled through a rights-based approach. Transformative effect of individual application, transition to a rights-based paradigm. As Mr. President has occasionally stated in his speeches, it can be said that interpretation within the constitutional jurisdiction is based on two basic paradigms. The first is the ideology-based paradigm, which adopts the strict interpretation of constitutional principles such as nationalism and secularism. The second is rights-based paradigm that primarily focuses on the protection of fundamental rights and freedoms. While the court used to make decisions in accordance with the ideology-based paradigm in the past, its current decisions are predicated upon the rights-based paradigm, which can be observed especially in the last decade. According to the rights-based paradigm, freedom is essential, whereas limitation is an exception. Therefore, the Constitution should be interpreted in favor of fundamental rights and freedoms. It is the individual application mechanism that has made the greatest contribution to the transition to a rights-based paradigm. It's also observed that with the contribution of the individual application, there has been a paradigm shift also in the constitutionality review. In line with the subject matter of the course, I will provide some examples related to this paradigm shift through some judgments. Constitutional grants regarding the right to vote and stand for elections and the court's precedent judgments. Right to vote, to stand for election and to engage in political activities is laid down in Article 67 of the Constitution of 1982. In this scope, citizens have been granted the right to vote, to stand for elections, to engage in political activities either independently or by representing a political party, and to participate in referendum. In a previous judgment, the court annulled the provision stipulating that the names of parliamentary candidates wouldn't appear on ballot papers, on the ground that the right to free elections entails that the voter makes a choice and casts his vote knowing all parties and candidates, whereas the impugned provision limited this right. In a recent judgment in terms of individual application, the court found a violation of the right to vote, to stand for elections and to engage in political activities due to the continuation of two precedents against the applicant who was elected as a member of parliament and was therefore entitled to parliamentary immunity in the absence of an exceptional provision set out in the Constitution precluding the parliamentary immunity in such case. As could be seen in these judgments, the court conducts an effective review through its judgments in terms of both constitutionality review and individual application regarding unconstitutional restrictions on the right to vote, to stand for elections, and to engage in political activities. Contribution to social peace. The court has so far rendered outstanding judgments playing a role in ensuring social peace and maintaining democratic order. It is well known fact that shortened matters leading to social tension in the past have been resolved through the contribution. Inter alia of the Constitution Court's judgments, one of these matters in the headscarf ban. Despite the explicit provision laid down in Article 24 of the Constitution safeguarding freedom of religion and conscience, there were previously relegations and practices that prohibit the wearing of headscarf in public institutions. At the outset, the court, along with the Council of State, interpreted the Constitution by adopting an ideology-based paradigm and endorsed and justified the imposed ban. In justifying his headscarf ban, the court employed the strict interpretation of secularism. However, the court departed from his approach through the judgments in rendered as from 2012 and instead adopted the rights-based paradigm. Interpreting secularism in a liberal manner through this new approach, the court found a violation of the constitutional rights of a lawyer expert from the courtroom of wearing a headscarf, a student expelled from university, and a public officer dismissed from office for the very same reason. Contribution to the proper functioning and improvement of a democratic society. In Turkey, the constitution maker envisaged that fundamental rights and freedoms may be duly realized only within a democratic social order and thus introduced the criterion being compatible with the democratic order of the society, which is set forth in Article 13 of the Constitution as one of the grounds for restriction of fundamental rights and freedoms. According to the court, in order for a restriction to be compatible with the requirements of a democratic social order, it must meet a pressing social need and be proportionate to this criterion. It will be assessed with there is a reasonable relationship of proportionality between the aim sought to be achieved and the means employed through a given restriction. In various judgments, the court found a violation due to incompatibility with the requirements of a democratic social order. The grounds relied on by the Constitutional Court in finding a violation in these judgments are as follows. The inferior court's failure to provide a relevant and sufficient ground to demonstrate the impudent blocking of access to the website had a pressing need. The inferior court's failure to assess whether the impudent blocking of access to online curtains was compatible with the requirements of the democratic social order. Conclusion. As could be inferred from the above cited precedents the Constitutional Court of the Republic of Turkey has made, two decisions and judgments issued on the basis of a rights-based approach significant contribution to the ensuring of social peace, for elections and a democratic order within the society. Thank you for listening to me. Thank you.
Thank you to Mr. Seljuk Tilik. And the next is from Ms. Dulam Suren Dasdonbok from Mongolia. Please, ma'am, the floor is yours.
Thank you, Mr. Moderator. Good afternoon. Please accept my sincere gratitude to all the speakers and distinguished guests who are participating in this short course. And also, I would like to extend my sincere gratitude to the host, Constitutional Court of Indonesia, for providing us with the opportunity to participate in this meaningful short course. Mongolia adopted a new democratic constitution in 1992, which legislated human rights, freedom, and form of state organization, the separation of state power, and the authority of the highest executive organ exercising that power. Moreover, Mongolian constitution defined democracy as our basic method of public governance and the right of citizens to elect and right to be elected, which is a fundamental value of democracy and fundamentals of election law. Each country has created its own state institutions by the law and its own methods and forms of conducting elections, and its legislation is the basic foundation for guaranteeing the citizens' right to elect and to be elected, the principles of election and the election system. Therefore, the purpose of this paper is to present the right to elect and the right to be elected and the parliamentary election system, its implementation and current situation, and some of the decisions of Constitutional Court of Mongolia that resolve disputes related to the election system. State structure of Mongolia and principles of election, method of defining election structure, implementation of the right to elect, guarantee of the right to elect and the right to be elected, and its criteria, provision, rules were set in the 3rd chapter of Mongolian constitution. For example, if a citizen at the age of 18 has a right has a right to vote, and the citizen who has reached the age of 25 has the right to be elected as a member of State Court Horal, which is the Parliament of Mongolia. These criteria for being eligible to be elected in the legislature. Mongolia held parliamentary elections for 9 times and approved 5 parliamentary election laws. In Mongolia, the system has gone through a number of changes since 1992. Until 2012, the plurality system was used, which is the largest vote getters wins the seat. Within the category of plurality systems, Mongolia moved from a multi-member district system to a single-member district system, and back to block voting in elections of 2008. All of the above points to the great instability of election laws changing after each election. Therefore, according to the recommendation of international organization, it is useful to reflect the chosen electoral system in the constitution that to prevent by the majority in place to change the election laws. Otherwise, the majority party in the parliament will permanent temptation to choose a system as they see fit and change the election law accordingly. As mentioned above, according to the law on Parliament, which was adopted in 2019, 76 members of Parliament, which is a unicameral parliament, shall be elected from multi-mandate by the majoritarian system. Constitutional Court of Mongolia have made several decisions related to the right to elect and a right to be elected, and also the electoral system. A selection of these decisions will be presented under the next topic. In 2011, a new election law introduced a combination of this majoritarian system and proportional system based on the ratio of 48 to 28. In other words, 48 of 67 parliamentary seats are reserved for individual candidates nominated by their parties, while the remaining 28 seats are reserved for political parties. Small parties favored in the proportional system because it would give them a better chance to gaining seats in parliament. According to the new law, in order to gain a seat in political party, they must get 5% of the total national vote. In 2016, parliamentary election was supposed to be conducted using mixed system. However, it was ruled out by the decision of Constitutional Court as violating the Constitution. Accordingly, changes were made to the election law, and the parliamentary election of 2016 was conducted based on a single-member district system. External observers noted that this as a regressive step. It led to a serious vote bias result. Here, I would like to give an example of a case study. Some disputes have been reviewed by the Constitutional Court of Mongolia related to the electoral system. That includes, there were 2 resolutions which is from 2012 to 2016 were inconsistent in content. Court reviewed decisions of 2012 and the 2016 were valid at the same time. So Constitutional Court reviewed the above-mentioned decisions in full bench session in June 2022, according to the resolution number 1, 2022 of Constitutional Court of Mongolia. These decisions were made annulled, and it was finally that the determination of an electoral system is matter of the mandate of the State Court Choral of Mongolia, which is the Mongolian Parliament. In addition to the decisions by Constitutional Court regarding the violation of the Constitution, the decisions with the content that the Constitution has not been violated are also important because they set a precedent to be taken into account in the future. In 2020, the Constitutional Court reviewed the dispute regarding the regulation on the prohibition of candidacy under the law on election. If the candidate involved in crime of corruption, crime of official position, and determined by the court guilty, then the candidate is prohibited to enter into an election. It is considered that the regulation was approved within the framework of the provisions of the international agreement and obligations assumed by Mongolia. The related legal regulations and the policy of ensuring the rule of law without corruption, and the issue the conclusion that the Constitution was not violated. This is an important decision made in the direction of guaranteeing the right of citizens to vote, ensuring that the public governance is free from corruption, and ensuring implementation of international agreements that Mongolia has joined. For that, to conclude, with the improvement and sophistication of legislation, democratic elections, their implementation, electoral system, its principles, right to elect and the right to be elected, and the guarantee of the right will also be able to evolve and develop. Mongolia is a developing country, and democratic elections and the electoral system, which are the values of democracy, is also developing. The process of evolution and renewal of electoral law and its system in Mongolia is still ongoing, and the Constitutional Court of Mongolia is contributing to this process. Thank you very much for your attention.
Thank you, Mr. Ambassador. And for the fourth participant is between Ms. Sumaporn Srimong or Mr. Sakunpong Trisompong. Have you already decided? Yes. Please, Ms. Sumaporn, the floor is yours.
Good afternoon, all distinguished participants. I'm Sumaporn Srimong and my colleague Sakunpong Trisompong from the Constitutional Court of Thailand. First of all, we would like to thank you, the Constitutional Court of Indonesia, for providing the great opportunity to attend this short court. Before we start the experience of the Constitutional Court of Thailand, I would like to inform that the competence of the Constitutional Court of Thailand regarding the election is limited, so there are few number of Constitutional Court ruling concerning elections and democracy process. As well as we will show 3 selected court rulings. The first case is presented by me and my colleague will follow to explain 2 cases and the conclusion. First case is the arrangement of polling station case in 2006. May I say a little background of this case? There was political crisis in Thailand between 2005 to the year 2006, such as the corruption and the conflicts of the interests of the political holder in the government. The civil protests took place in several times so that the Prime Minister dissolved the parliament and then the Election Commission announced the general election of the member of the representative on the 2nd of April 2006. But after the election day, the Ombudsman asked the applicant filed the case to the Constitutional Court for a ruling on constitutionally problem concerning the election Commission proceeding with respect to the general elections held on 2nd April 2006. The applicant said that the arrangements of polling station in such a way that the voter faced the polling station while turning their back on the election unit committee, and other voters who arrived to exercise their voting right, as well as third party observing the election at the unit. The applicant also stated that such arrangements polling stations was a violation of the principle of voting, which had to be carried out by means of direct and secret vote. Even though the Election Commission explained that the new arrangements of polling station would enable to polling unit election committee to observe the behavior of voters while casting their vote. The Constitutional Court found that the format of arrangement in the polling station in such elections causes the casting of vote by eligible voters to be made within distance of the constituency election commission, which was also represented by political party fielding candidates in such consistency to visibly observe the casting of vote by eligible voters. Such new arrangements of the polling station therefore render the vote in the elections of members of the House of Representatives to be made not by means of secret vote as required under the Constitution. The Constitutional Court found that such general elections with the arrangements of the polling station pursuant to the resolutions of Election Commission produced unfair election results that were not truly democratic, and therefore the elections were unconstitutional. After the decision, that election was declared invalid by the Constitutional Court, and then the new elections was scheduled for October 2006.
The second case is the case of 2007, which led to 20% minimum votes rule avoidance. The rule is stated in the election law at that time, the 1998 Organic Act. The rule shall apply if there is only one candidate standing for an election on a constituency. Such candidate must receive votes at least 20% of the total number of the voters in that constituency to be elected. In this case, there are 3 respondent political parties. The third respondent party financially sponsored the first and the second respondent party to fill election candidates to avoid the 20% minimum votes rule. They also conspire with each other in issuing false party membership certificates as evidence in election candidacy application. Finally, the Constitutional Court of Thailand issued an order to dissolve all respondent parties in case of committed acts to require the power to rule the country by any means, which was not in accordance with the provision of the Constitution and acts in hostility to the democratic regime. The third case, which took place in 2014, is called Same-Day General Election Case. In the 2007 Constitution provides that the election date must be the same throughout the kingdom. In the 2014 general election, there were no candidates in 28 constituencies. It was thus deemed that no general election was held in those constituencies. Hence, it was deemed that the 2nd February 2014 was not the day when a general election was held throughout the kingdom. The Constitutional Court ruled that the election was unconstitutional. This presentation shows the experience of the Constitutional Court of Thailand, which plays the important role along the principle of the supremacy of the Constitution and being the last resort for check and balance the election process to be free and fair election. Moreover, the decision of the Constitutional Court is the final and binding all state organizations. Hence, the Constitutional Court is one of the democracy mechanisms to maintain peace in Thai society via remanding the cases concerning election, such as said 3 selected cases. Thank you for your all attention.
Thank you for friends and delegates from Thailand. And for the next one is from the delegates from the Philippines. Please, between Attorney Maria Patricia Falena or Ms. Micha Celine Carpio, please, the floor is yours.
Good afternoon, everyone. So we are lawyers, Micah Celine Carpio, BB, and my colleague here, Maria Patricia Valena. We are law clerks in the Supreme Court of the Philippines. So we would like to thank the Constitutional Court of the Republic of Indonesia and of course all the speakers for all the enlightening and engaging discussions on your respective jurisdictions. To give some background on the Philippines, it is an archipelagic country divided into 17 regions, each of which is further subdivided into provinces, cities or municipalities, and barangays. The smallest political unit in the Philippines. Its national government is divided into 3 branches. First, the executive branch under the leadership of the President and the Vice President. Second, the legislative branch divided into 2 chambers, the Senate and the House of the Representatives. And lastly, the judiciary. The President, Vice President, Senators, and members of the House of Representatives are elected by popular vote. The President, Vice President, and Senators serve for terms of 6 years, while the members of the House of Representatives serve for 3-year terms. In contrast, the members of the Supreme Court are appointed by the President from a list of 3 nominees prepared by a multi-sectoral council with representatives from the Court, Congress, the private sector, and the academe. The members of the Supreme Court hold office during good behavior until the retirement age of 70. The Philippine Constitution was ratified in 1987 and provides for a democratic and republican state. Sovereignty resides in the people and all government authority emanates from them. All citizens of the Philippines who are at least 18 years old and who have resided in the Philippines for at least 1 year and in the place where they plan to vote for at least 6 months immediately preceding the election may exercise the right of suffrage. There is no literacy, property, or other substantive requirement imposed on the exercise of the right to vote. In fact, the Constitution requires the implementation of systems that enable disabled and illiterate persons to vote. However, the following are disqualified from registering to vote. First, any person who has been sentenced by final judgment to suffer imprisonment of not less than 1 year, such disability not having been removed by plenary pardon or amnesty. Second, any person who has been adjudged by final judgment by a competent court or tribunal of having committed any crime involving disloyalty to the duly constituted government, such as rebellion, sedition, violation of the firearms law, or any crime against national security, unless restored to his full civil and political rights in accordance with law. In the first two, the disqualified person shall automatically reacquire his or her right to vote 5 years after service of sentence. And lastly, insane or incompetent persons declared as such by competent authority unless subsequently declared by proper authority that such person is no longer insane or incompetent. In keeping with the broad right of suffrage ensured by the Constitution, and to ensure that members of the Philippines' large overseas labor force can participate in the national elections, the Philippines has a system of overseas absentee voting, which allows Filipinos abroad who are at least 18 years of age on the day of elections to vote for President, Vice President, Senators, and party list representatives. The Philippines also has a sangguniang kabataan in every barangay to enable and encourage the participation of the youth in the democratic process. The drafters of the 1987 Constitution emphasized that they chose the word democratic because of the need to underscore the participation of the people in the policy making and explained that democracy is reflected in the characteristics such as the existence of the Bill of Rights, accountability of public officers, and periodic elections, among others. To ensure free, fair, and peaceful elections, the Philippines has a Commission on Elections, or what we call as the COMELEC, which is responsible for enforcing and administering all laws and regulations on the conduct of elections, plebiscite, initiative, referendum, and recall. In the exercise of the COMELEC's mandate to ensure modernization of elections, it began implementing nationwide automated elections in 2010. I'll transfer you to my colleague now.
Thank you very much. So the next part of our discussion will focus on the resolution of election disputes. Now, when it comes to resolving election disputes, there are 4 main bodies that we need to consider. First, the COMELEC, which was mentioned earlier. Second, the House of Representatives Electoral Tribunal, or the HRET. Third, the Senate Electoral Tribunal, or the SET. And finally, the Presidential Electoral Tribunal, or the PET. So it's important to remember that the judiciary of the Philippines plays a role, whether or not even if the dispute is brought before any of these tribunals. So first, we'll discuss the COMELEC. The COMELEC has exclusive original jurisdiction over all contests relating to the election, returns, and qualifications of all elective regional, provincial, and city officials, as well as appellate jurisdiction, acting as a sort of court of appeals in all contests involving elective municipal officials decided by trial courts of general jurisdiction, or involving elective barangay officials decided by trial courts of limited jurisdiction. The COMELEC also has the power to decide all questions affecting elections, including the determination of the number and location of polling places, the appointment of election officials and inspectors, as well as the registration of voters.
However, the COMELEC does not have jurisdiction over questions involving the right to vote. The COMELEC is an independent constitutional body created by the 1987 Constitution itself. Thus, the Philippine Supreme Court has no general powers of supervision over the COMELEC, except those which the Constitution specifically grants to it. That is the power to review the decisions, orders, and rulings of the COMELEC within the limited scope of a petition for certiorari, which requires proof of grave abuse of discretion and not simply error in the ruling of the COMELEC. The HRET and the SET, on the other hand, are the sole judges of all contests relating to the election, returns, and qualifications of the members of the House of Representatives and Senate, respectively. So each electoral tribunal is composed of 9 members, 3 of whom are sitting justices of the Supreme Court and 6 members of the House of Representatives or Senators, as the case may be. Finally, the Philippine Supreme Court, sitting en banc as the PET, is the sole judge of all contests relating to the election, returns, and qualifications of the President and Vice President. So when the Philippine Supreme Court decides these cases, it is sitting as an entire body, but it is sitting as the PET and not as the Supreme Court. So the PET has only decided 5 cases under the 1987 Constitution, and it has demonstrated a careful approach to electoral challenges or protests. Recently, in its most recent decision, the PET stated that the power to annul elections should be exercised with the greatest care, as it involves the free and fair expression of the popular will. And it is only in extreme cases of fraud and under circumstances which demonstrate to the fullest degree a fundamental and wanton disregard of the law that elections are annulled, and then only when it becomes impossible to take any other step. So this statement demonstrates the philosophy of the Supreme Court sitting as the PET in resolving election disputes, the conservative approach that it takes. The PET has also stressed that an election protest is not an ordinary petition or dispute because it may result in the deprivation of a significant portion of the voting population of the right of suffrage. And because of this extraordinary nature of electoral protests and in the interest of due process, the PET takes pains to afford the parties every opportunity to present their case. So in conclusion, the Philippines actually had its most recent general elections on May 9, 2022, with Filipino citizens electing the President, Vice President, Senators, Congressmen, and local officials. Voters' turnout was reported at 84.1%, with 0.10%, with 55,290,821 people voting out of more than 65 million registered voters. The Office of the Presidential Advisor on Peace, Reconciliation, and Unity described the elections as generally peaceful, orderly, and organized. Thank you very much.
Thank you from the Philippines, our friends and delegates. Thank you very much. And we will continue this session with, I will give opportunity for the participant to ask question or maybe to clarify something from any presenter or any presentation that have been delivered today. And of course, after that, we can have the coffee if you haven't got yours yet. Any questions? Please raise your hand.
Can I?
Please, Mr. Hani first. Please, Mr. Hani.
Thank you, Chairman, President Eri. Yeah, in Indonesia, one of the big issues related to the election is about money politics. In each election, the candidate always give money to the people. And it's difficult for us as a court to handle this issue. I want to, is there any experience from your country, or from your court, how to handle the issue of the money politics related to the election? Especially if they come to your court and then it becomes the case. Thank you.
And the question directed to which?
To all speaker,
To all
to all speaker, from 5 speaker. Thank you.
Thank you, Mr. Hani. And next question from Mrs. Silalahi, please.
Thank you, Mas Eri. Excellent export of all speakers. From several speakers, the Constitutional Court has the obligation to maintain the constitutional rights of every citizen, including the right to vote and be elected as equals. Let me ask to the delegates, to the speaker of Kazakhstan, Turkey, Mongolia, Thailand, and Philippines, is the settlement of cases submitted to the Constitutional Court in your state given a grace period for the completion of a case? Can you explain to us? Thank you.
And the next question is from Mr. Tarigan.
Thank you, Moderator. My name is Jeffrey Tarigan. I'm Substitute Registrar in Constitutional Court of Indonesia. Thank you for our participants for your great presentation. This question was addressed to the delegation from Turkey. There are two paradigms based on your presentation applied by the Constitutional Court in Turkey. There's two paradigms, a straight ideological approach and basic rights approach. My question is how the Constitutional Court in Turkey deals with human rights and the rule of religious law. Which one is more prioritized, or which one is more dominant between religious law or human rights? If there is a conflict between two aspects of the rules. Thank you.
Thank you, Mr. Jeffrey Tarigan. At this moment, we have already 3 questioners, and I think for some question we need a little more time to answer and maybe respond, because the question is very wide, and it's a very good question and something to discuss, something that worthy to discuss in this session. And there's a question from Mr. Hani, how the court or your country or every institution in your country in dealing the money politic issues, because it happens everywhere. And from Ms. Wilma Silalahi, there's a question about grace period or time limitation and finishing finishing every cases in, because there is also time limitation that provide burden to the court. And from Mr. Tarigan, especially question for Turkish delegate about human rights and religion, about the relationship and dominance. And based on this program, I would like to ask first to Ms. Nigora Marifova from Kazakhstan if she wants to comment or respond on the question from Mr. Hani and Mrs. Wilma Silalahi. Please, Ms. Marifova.
If I correctly understood the first question, what is the contribution, money contribution of the candidate who is going to run the elections for the president, you mean, or what?
Yeah, related to the issue of money politics, from each candidate to the people, how your court handle the issue. If this become case, if it's become case in your court, or how your country handle about this issue?
The Constitutional Council has a mandate to check the results of the elections, if they occur. The results of the elections, they review. If there is if the results of the elections are contested, the Constitutional Council has a mandate to review these results. Maybe I didn't understand your question properly.
Yeah, exactly my question, how your court handle the issue about money politics? Because in Indonesia, money politics is become big issue, and it's sometime this issue will become the case to our court.
You see, so far we hadn't had such cases in our council. Maybe in future. And the second question is the term of consideration. Yes, the term of consideration of the cases. According to the law, the Constitutional Council should consider the dispute on the results of the elections during the term of 1 month. And at the request of the President, it can be reduced to 10 days.
Thank you, Ms. Marikova. And from Turkey, maybe you want to respond or the comment about question regarding the relationship between law, order, and the religions matters in Turkey.
Yeah, thank you. Actually, at last, before 2012, in Turkey, the Constitutional Court of Turkey handled this matter as ideologic, and human rights reduced according to right-based. And so actually our president acted the president after 2012. Turkey has changed a paradigm shift from ideologic-based paradigm to right-based paradigm. For example, handscarf ban had a big problem in Turkey to entering any university or the other places. But then now, after Turkish Constitutional Court had a decision after this matter, we fixed up this ban, for example. And so now I think we have a good relation between the balance of human rights and the religion. So I think we have a good position about that. Thank you.
Thank you. And from Turkey also, there is one question from Ms. Silalahi about, is there any time limitation for the court to complete any particular case in the Constitutional Court of Turkey? Time limitation, a constitutional time limitation. If there is so, and how much of the time limitation and which it was regulated? Thank you.
Actually, after we have individual application, our job has gone to very much, and we have 1,020 cases now for individual application per year, and we have just only 116 rapporteur judge and 15 members. So it's a big problem for Turkish Constitutional Court, but some techniques we have, and we need to try this problem, and Turkish Constitutional Court decided 90 cases in last year. And then we are the rival of European Court of Human Rights. Our president says everywhere this. Okay, that's a problem, I think.
Thank you from the Turkish delegate. And the next delegate that should respond from the question is from Mongolia, Ms. Dulam Surendastondok. There is two questions actually. First, it's about how you, the court handle with money politics cases in election especially, and whether the court in particular cases had time limitation or grace period so the court have to complete any cases. Please, you could maybe give some response. Thank you.
Okay, thank you. For both cases, we haven't come across, until now, we haven't come across with any kind of a case study right now. So, as I mentioned in my presentation, if the candidate or to-be candidate involved in a crime of corruption and the crime of official position, and the court determined if that candidate, like beforehand, involved and guilty of that crime, that candidate won't be able to enter into election. So it is, it doesn't, it's that principle is still in the Constitution and still in the election law, and it's still binding. So that means that the limitations of money politics is narrowed down. Thank you.
All right, thank you. And from delegates from Thailand, is there any response you want to present from our question today?
I would like to answer the first questions about the money politics in our court. But in the Thailand, it is not the jurisdiction of the Constitutional Court of Thailand exactly, but it depends. It's upon to the Supreme Court and the Election Commission. It depends on the time of the time, because if the case prior to the announcement of the result of election, the power is belong to the Election Commission. To if the case caused the election to be dishonest and unfair, the Election Commission can temporarily suspend the election rights of a candidate for a period of not more than 1 year. Yes, and additionally, the Election Commissions have the power to order a new election. But if the case took place after announcing the result of election, this power is belong to the Supreme Court, and the Election Commission will send the case to the Supreme Court in Thailand if this appear evident to reasonably believe that candidates of the elections have committed a dishonest act in the elections. The Supreme Court shall decide to revocations of the right to stand for elections or the right to vote of such person for a period of 10 years. That is the questions. That is the answer. But in the second case that my colleagues explained, it is in the previous constitution. Is like if you overthrow the democratic regimes, it belongs to the Constitutional Court to rule on it. and my colleague will answer the second question.
The second question, I thought that it's about the period of the process of the Constitutional Court reviewing the case. The Constitutional Court of the Kingdom of Thailand have no specific period that have to decide the case, except for some urgent case, emergency case, just like the case about bill of the expenditure, bill that have to decide within 15 days. Okay, about the third question.
The third question is about the human rights.
Okay.
It's fast. Yes, that's true because the human rights is of the Turkish.
Okay, thank you from our delegates from the Kingdom of Thailand. And for the next participant that should respond is from the delegates from the Philippines. Will you have any response for the questions by the questioner? Thank you.
Thank you, Mr. Moderator. Okay, for the first question with regard to the question on money politics. So in the Philippines, we actually have laws setting the spending limit of the candidates during elections. And there are also laws about the contributions and donations to be given to the candidates during elections. So the limitations vary depending on the position they are running and on the place where they are running. And also, the candidates and the donors are required to actually submit a statement of contribution and expenditures during elections. And then, as to the second question, the grace period. So, based on our 1987 Constitution, all cases submitted for decision shall be decided by the Supreme Court for within the period of 2 years. Thank you.
Thank you very much from the Philippines. And for those of you who agree that maybe probably it's time for us to just complete this session and joining me for a coffee time, a coffee break for the second mess, maybe you could raise your hand. Should we complete this session for right now? Anyone agree? Yes, agree? Okay, thumbs up. All right. Now, thank you very much for your participation. And before I conclude this session, I would like you to give yourself a round of applause because you're being a very excellent participant. Thank you. And also thank you for the committee for organizing this kind of very excellent short course. And we hope to meet again in the next short course, of course. And probably you're still wondering why the time is very limited because we should have another meeting and you could prepare for the closing ceremony and you can enjoy your coffee time and coffee break, and after that we meet again for the closing ceremony. And I personally will mention that this is my closing statement, and because thank you for attention and thank you for your participation, and hopefully that everything that we achieved today is very useful for your role in each institution back in your home country. Thank you very much, and Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much. Once again, can I hear a pulse, ladies and gentlemen? So that's the end of the second part of the last session, actually, the final sessions of the short course at the last 2 days. Thank you so much. And now, as mentioned before by Mr. Eri, we have a short break, around 15 minutes. And after that, we will continue to the closing ceremony or the closing session of the 5th International Short Course for Legal Officers. So please be back here at 15:30. So we will continue to the closing session of the short course. So enjoy your break. Thank you. Excellencies, distinguished guests, participants, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. May peace be upon us all. Good afternoon. I'm delighted to announce that we have come to the end of the 2 days program. And this is the closing of the 5th International Soul Course for Legal Officers with a theme of peace, election, and democracy. It is such an honor to introduce and welcome our distinguished guest, Mr. Muhyiddin, Chief Registrar of Constitutional Justice of the Constitutional Court of the Republic of Indonesia, and also all discussants and participants of the International Soul Course. Ladies and gentlemen, without any further ado, I would like to invite Mr. Muhyiddin, Registrar of the Constitutional Court of the Republic of Indonesia, to the stage to deliver his closing remarks as well as officially close the program. To the Honorable, please, time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Honorable Mr. Jeffrey Epperson, Vice President for International Relations of the National Center for State Court, the United States of America, representative of the Aacc members, participants on the short course, ladies and gentlemen. Praise be to God for His blessing, so that we can gather here to attend the 5th International Short Course for Legal Officials. The Short Course program is part of the 5th Congress of the World Conference on Constitutional Justice that is attended by 94 courts as well as organizations from various backgrounds. All has the same objective, that is to build the synergy of knowledge which hopefully could be implemented in their respective countries and organizations. In line with that, we hope the positive collaboration can be made in the effort to build cooperation through exchange of information. Through this short course, we also learned many new knowledge and perspective concerning peace, election, and democracy, as it is my theme from speaker and all participants. With regard to the work of the Constitutional Court, ensuring the constitutional obligation are carried out is important to achieve social justice. However, the court cannot walk alone. There must be a collaboration with other branches of the state power to enable transformative constitutionalism, as one of the speakers argued. Concerning the relation between election and welfare, in this belief, the election lead to prosperity so long as several conditions admit, among others, are well-informed voters, accountable monitoring institution, and ensuring free and fair election. The Constitutional Court plays one important role for this matter. This is to decide on dispute on election result. The court ensures that rights of all citizens are guaranteed. With this crucial role within the society, it is important for the Constitutional Court to maintain trust from the society. It can be done by establishing transparent and accessible court system and enacting code of conduct. There are many more that we can learn, but it will be too long if I'm to list all of them. Finally, I would like to express my gratitude to all the speakers and moderators who participate in this activity and the committee directly and indirectly. The success of this event is possible due to great collaboration and initiative. I would like to thank all participation for dedication and active participation, input, and suggestion on this issue related to peace, election, and democracy. Once again, on behalf of the Constitutional Court of Indonesia, I would like to apologize for any shortcoming. We welcome any input and suggestion that will be beneficial for us in the future. Good afternoon. Enjoy your stay in Bali. Billahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. I hereby close this short course.
Thank you, Mr. Muhyiddin. Please kindly stay at the stage. Ladies and gentlemen, we invite all of you to come up the stage to have a photo group. Please. The last photo sessions, actually. Freestyle once again. Please everyone say Bali. Bali. Get it? Okay, once again, applause everyone. Thank you so much. Well, now we have concluded the 5th International Short Course for Legal Officers with the theme of peace, election and democracy. On behalf of the Constitutional Court of the Republic of Indonesia and all the committee, I would like to thank all participants for your active participation during the proceeding of this event. Tomorrow, ladies and gentlemen, we will have cultural activity, Wonderful Indonesia. Please wear your most comfortable clothes and enjoy the program. And I would like to remind you as well, we have the farewell dinner will be available at Taman Bagawan at 7:30 p.m. Once again, the farewell dinner will be available at Taman Bagawan starting at 7:30 p.m. Good afternoon. I'm Anak Agung Yumas. Wassalamualaikum warahmatullahi wabarakatuh.